memories that could be fast. 'Cause I have found a path to share life with heaven tell. It only takes a spark for a fire to start. Won't hesitate, we'll fan the flames. That is the way we'll make our own future. I'm gonna reach that finish line without a inches at a time. I'll keep going, nothing can stop me. Na 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 na. They say that we're not strong enough, but I ain't never giving up. And I'll leave this future behind me. Na 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 na. I'll keep going, nothing can stop me. Na 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 na.
Well, hello everyone, and welcome to another fun time on Extra Extra as we get ready to take care of some lawsuit legal stuff. Next week is the 2004 discovery hearing for the metamaterials bankruptcy, and boy, has that docket been active, busy. It's kind of silly how busy it's been, but then again, we've had a bunch of stuff going on to get ready for that hearing. Also, it looks like maybe they'll sneak in NASDAQ there because its briefing schedule got done. I was not expecting that to happen. Switch to the headphones just in case we need audio. I don't think that'll be necessary, but we shall see. Oh my goodness. Let's flip over to the main screen and we'll take a look at things here. I will say at some point we will be switching from light alcohol to enjoy the weekend to a little bit more heavier stuff because we got some silliness. We have some definite silliness going on in the metamaterials bankruptcy that's going to require additional inebriation to get through without full body cringe. I'll let you know when that gets there so that you can prepare ahead of time. But as far as we're going, we've got stuff in here that I've even missed from back in January that has been going on that I didn't even realize was up and going. So we'll get to that as well. But first, this was the big rage, I think, from last week with the baggies, as it were. They were trying to turn this into proof that the bankruptcy judge was siding with them already before the hearing had even happened. I'll let you on a little secret. Judges usually don't fucking do that. If that wasn't clear. But this was to deal with one issue that I think even during the original hearing that the judge was just having none of, and that was Local Rule 2004C. If you're not familiar with how courts operate, there are the general laws that are set out and general rules based on, the law and everything like that. And then you've got case law based on rulings. And then there's local rules, which are basically rules for the specific administration of that court. And that's what we're talking about here with, Local Rule 2004C, which, as it says, has to do with 2004 discovery. And the judge is basically laying down the law that anything to do with that, subdivision C is amended in two respects. First, it's the provision it follows that especially to the production of electronically stored information in addition to the production of documents, this change is an acknowledgement in the form in which information is now commonly existed. Second, subdivision C is amended to bring its subpoena provision into conformity with the rest of the Federal Rules of Civil Procedure 45. In light of the advisory notes, the court cannot read the local rules to prohibit what the federal rules provide. You're just clarifying, because this has been a point of contention at the hearings and in the filings from everybody as to how they've interpreted it. And so the judge is just like, we're gonna nip this in the butt here. That I'm gonna deny any motions to quash based on that one narrow local rule. That's it. So that was from last week. Yes, was filed on the 9th, so actually it might have been the beginning of this week. Hello! So yeah, on Monday is when this was filed, and everyone was batting that around like it was some big proof about everything. Then we got NASDAQ who came in. For people who aren't aware from previous episodes of Truth Be Told, we, in fact, actually, did this happen? Yeah, because it was the other one, I should know it. The FINRA one was approved last week. So both have now been transferred over into the Nevada Bankruptcy Court. Yeah, NASDAQ in shambles. Yeah, so on the 29th, we had totally missed this. NASDAQ had responded on the motion, had responded in the Nevada court as to the motion to quash. This is just a refiling of what they filed in the court. So over in, I think it was the Southern District of New York. So we're not going to go over this because we have gone over this before. Maybe not in super detail because I think it was during an extra. I mean, not during an extra. It was during a Truth Be Told, and I usually don't go super in depth on those, but that's been filed on the bankruptcy docket here as docket ID 2551, which should tell you exactly how bad bankruptcy dockets can get. We're already, up to docket number 2551. So that takes care of that. We then got this motion and opposition to the motion to quash, which I believe is a brand new filing. I don't see anything on here to suggest it isn't any different, but they filed it at the same day, like bang bang. So I personally assume that this is just a copy pasta of what they filed in the Southern District of New York. So we will also skip that. But just to let you know, also, it is docket ID 2554. When you're like 3 docket entries away, I think it's pretty safe to say that that's that. What is new and was filed today was NASDAQ's reply in further support of their motion to quash. That was the new one that dropped today, which makes me think that they're going to try and squeeze this into the hearing next Friday, which is going to be at 1:30 Mountain Time. That will be 3:30 on the East Coast. If you believe in that make-believe time zone, notice the East Coast. It is 2:30 Central, the only real time zone in America. So let's break into this one. I have a feeling that, it's Pacific time. Oh, I thought it was Mountain Time there in Nevada. They go by Pacific Time? Well, that bumps it back even further. That would mean it's 3:30 Central, 4:30 Eastern. Well, dang. I'm gonna get plenty of time to do this. I can, have a rushed dinner and then do a live stream on it. I may even be off of work by then. NASDAQ stock market respectfully submits this reply. Yeah, that's the basic intro. Background, we know the background. Let's get to the reply. The subpoena should be quashed because A, the request is substantively improper as it is barred by Bankruptcy Rule 2004 scope and purpose, and the request is procedurally improper and barred by Civil Rules of Procedure 45. I may skip over this one because theirs is not as meaty as the response by Citadel, Virtu, and Anson fund. It has materially the same stuff, so we may skip around just so I don't ruin all the fun when we get to the other one. This is a commercial Chapter 7 bankruptcy. Bankruptcy Rule 2004 permits the trustee to examine an entity only if it relates to a debtor's acts, conduct, or property. the debtor's liabilities and financial condition, or any matter that may affect the administration of the debtor's estate. Even the specific topics allowed by Bankruptcy Rule 2004B must be read in the light of the general restriction of inquiry into the financial affairs of the debtor. The request is outside the scope of Bankruptcy Rule 2004. Request is barred by Bankruptcy Rule 2004 scope. The trustee asserts that its Bankruptcy Rule 2004 investigation is a fishing expedition intended to conduct pre-litigation discovery to assess whether viable claims exist against any parties related to the possible metamaterial stock manipulation. The trustee is looking for patterns of manipulation, stock trading across the industry for metamaterial stock. Specifically, the trustee is concerned with investigating the debtor's pre-bankruptcy sales of its own stock based on the trustee's belief that manipulation of metamaterial stock might have affected the price that the debtor has attained in the stock sales, thus affecting the debtor's assets. The trustee's opposition loosely ties these efforts to the debtor's estate and its financial condition with conclusory statements. The request does not relate to debtor's property or its financial condition. The request is not limited to the debtor's own assets or conduct, which the trustee would naturally possess sufficient records for. Rather, the request seeks records related to all third-party stock trading activities of the debtor's equities over a 4-year pre-petition period. The opposition asserts that the trustee may hold vague speculative potential claims against third parties related to stock manipulation. The trustee's opposition does not articulate any actual claims. Rather, the opposition asserts that the trustee is uncertain as to whether claims even exist. Oopsies. Yeah. The opposition fails to provide a basis for the court to find that the request constitutes a valid investigation into the debtor's property or financial condition, or that the trustee has standing to prosecute claims related to stock manipulation of the debtor's equity interest for the benefits of its shareholders. Bankruptcy 2004 would become limitless if every request for 4 years of third-party stock transactions records to explore potential claims or to qualify as a proper investigation of the debtor's property and financial condition. The subpoena should be quashed because they admittedly seek to conduct a wide-reaching fishing expedition for potential claims that the trustee does not even have standing to prosecute, untethered from the proper scope of Bankruptcy Rule 2004 examination. The request is barred by its purpose. Yeah, that's pretty straightforward. You know, one thing I don't like about NASDAQ's lawyer is he's very straightforward and he has very few barbs. That's why I'm kind of glazing over it so we can get to the response by Virtu and Citadel and Anson funds, because they definitely barb quite often. They are not happy about this motion at all or having to deal with it, and considering the amount of litigation that they've had to deal with because of West Christian, I don't blame them. Request is procedurally improper. Again, this one's, Rule 45 requires that you actually have to have a pending action that grants you the Rule 45 discovery. You can't just I want discovery without there being an underlying cause. Your standard subpoena objections that it's unduly burdensome, irrelevant, and overbroad. Especially redundant, because they could also get this same information from other parties. Like that's a key thing of it. Say if someone was suing, Amy, and they wanted Amy and mine's communications. Like if 90% of our communications she already has, and like there's no need to subpoena me for communications if it's overly redundant and you can get the same information from Amy. Now, if there was potentially missing communications, then you could say I want those, but like redundancy, if it's overly burdensome, if there's a bunch of communications but it doesn't match the the level of the request. Like, say there's some, I don't know, if I got in a car wreck and I wanted the communication logs of the other person it was in a wreck with, and I wanted all of them. Not only is that not narrow enough, but it's just overly burdensome on its face. I know it's kind of a meh explanation, but as far as like I'm just trying to come up with analogies off the top of my head, and it's 8 o'clock at night. NASDAQ provides records in its July production for the 6-month period of greatest interest the trustee's special counsel. In other pending subpoena disputes, the trustee has highlighted NASDAQ's July production as an example of responsiveness. The July production diminishes the trustee's need for additional 3.5-year records, whereas the burden on NASDAQ to provide the additional 3.5 years of records would be magnitudes greater than the burden it had already incurred. Notably, the opposition does not propose any accommodations to mitigate. Yeah, that's pretty key. Time and expense that NASDAQ would incur in its production. The party's attorney is responsible for issuing and serving a subpoena must take responsible steps to avoid imposing undue burden or expense on a person subject to the subpoena. Requests are irrelevant because, yeah, some of this stuff like Torchlight and metamaterials, not metamaterials, but MMTLP is just like whatever. Yeah. So that's pretty much the end of that one. Previously, on a previous episode, we had the trustee's response to non-parties. I'm just leaving this here in case we need to reference back to it for what I really want to get to, which is, get rid of that, which is the response by Anson Funds, Citadel, and Virtu. This one is less dry and much more cutting and much more entertaining. So let's strap in. This dispute is not about the breadth of Rule 2004 in the abstract. It's about whether Rule 2004 can be used to compel discovery from the non-parties when the trustee has not identified a single cognizable claim belonging to the bankruptcy estate. It cannot. The trustee seeks years of trading data and communications from Citadel Securities, Anson Funds, and Virtu Financial, entities she does not contend had any connection to the debtor, based on the theory that third-party secondary market trading in metamaterial stock might someday support a securities law claim. But Rule 2004 discovery does not permit the trustee to seek pre-litigation discovery into third-party conduct absent a debtor-facing nexus, nor does it permit the trustee to pursue discovery for claims not belonging to the estate. As the party's opening supplemental brief made clear, the trustee's theory rests on a categorical error. Shares traded in the secondary market are owned by the shareholders. That is really big and key there. Once the company sells them, you are the owner of them. They are proof of your ownership interest in the company. And you can trade them freely. Like it's like if Ford sells you a car, it's no longer Ford's car, it's your car. Claims arising from those trades, if any, belong to the investors who trade the stock, not the debtor, and not its trustee. The trustee herself said as much. In seeking authority to retain special litigation counsel, she represented that her contemplated litigation would provide for recovery for shareholders, which means that she can't bring it because it's not a claim of the estate. A bankruptcy trustee has no standing generally to sue third parties on behalf of the state's creditors or shareholders, but may only assert claims held by the debtor itself. Rule 2004 cannot be used to pursue discovery and service of claims the trustee had no standing to bring. The trustee's supplemental brief provides no answer to this threshold defect. The court instructed the parties to provide beefy, long, detailed, heavy citations on the standing issue. That's the, I assume, a citation to the transcript, which we don't have. I wish we did. The trustee, I think it is in there somewhere. I just would have to go looking for it. F. Oops, hit the microphone. Yeah, there's apparently no transcript on the docket, which is disappointing. Oh well. It might be back there later. I'll go search for it when it becomes available. Because I think it'd be a fun read too, even though I listened to the hearing. Most of you I don't think did, so. She cited virtually no authority supporting her position and did not identify a single sale of stock by the debtor. The part here, like, because their big argument throughout this has been that, well, sales of stock by the estate, the former company, would be something that the trustee would have claims to, and that's fair enough. But like, they haven't named any, so like, how can you have discovery for claims you haven't even brought yet? There's no, like, what are we doing here? The failure to answer a central question of standing, whether and when the debtor was a seller of stock, is alone dispositive. And even if the trustee had standing, she does not explain, because she cannot. See, the snark, it's coming. Why her counsel needs pre-suit discovery from the non-parties when the same counsel has filed identical claims in other courts using only publicly available information, or why her claims are not barred by the doctrine of in pari delicto, which we covered last time when we dealt with the original response by these three parties. Basically, it's about weighing the guilt. Like, if you're gonna accuse me of something, of like some sort of civil wrongdoing or something like that, and you've had a hand in that wrongdoing, then we need at very least to measure who did the more wrongdoing, me or you, so we can assess who is really in the wrong here as far as damages are concerned. And if you are just as much in the wrong as I am, well, then you can't exactly sue for that, because you kind of also did some stuff. So it's like, at best, they're saying at best they have a balance of equity situation, and at worst, they can't bring claims at all. Rather than confront these fundamental issues, the trustee argues that Rule 2004 allows her to search first and then determine standing later. But as the court recognized, whether the debtor itself was a seller of the stock, and thus whether any claim could belong to the estate, is too fundamental an issue to be deferred. Moreover, the trustee reframing Rule 2004 would set a dangerous precedent. Any trustee in a public company bankruptcy could compel discovery from market participants nationwide simply by alleging that the trading activity affected a debtor's stock price prior to the bankruptcy filing. This is a kind of argument that you see a lot in the Supreme Court, like briefs and case standing. As much as people, like, when you're making an argument, obviously you're going to think narrow. What can we do? What's reasonable? But you also have to look at where your logic is carrying you. If you're saying that you can do this like 2004 discovery into trading activity in your stock, you're basically saying that we have the right under 2004 to do discovery on all trading activity on our stock against all market participants at any time, and they have no rights. We can just ask for discovery because it's a bankruptcy court. That's absurd. That's fucking absurd. And that's what they're pointing out here. It's like, you can't just look at the narrow argument of, oh, we promise this is all we're doing. We have to look at, how does this apply when other people start using this same sort of precedent in other bankruptcy hearings. And you have to take it to its logical endpoint, which is that if you're okay with this, then there is no limit. They can basically go out and subpoena anyone and everyone's stock trading transactions in metamaterials under 2004 if you believe what the trustee is saying, which is absurd. Moreover, we already did that. 2004 does not permit the result that which would reverse the government's framework. Yeah, you can't, law. That's another key thing about law. People don't write things that mean nothing. So if your interpretation of the law erases part of the black and white law that Congress, passed and the president signed on, then your interpretation is void. It doesn't make sense. After 2.5 years of investigation with access to corporate insiders, the trustee still cannot meet either requirement. The subpoena should be quashed. Stock owned and traded by third parties is not property of the estate. For the reasons detailed in the non-parties opening supplemental brief, stock traded between and among third-party investors in the secondary markets is not property of the debtor's estate. The trustee's supplemental opposition does not dispute this core proposition. She offers no authority because none exists for the notion that shares held by investors constitute legal or equitable interest of the debtor in property under Section 541A1. Her attempts to avoid this critical limitation fail for several reasons. First, consistent with the court's instructions, the non-parties opening supplemental brief provided beefy, long, detailed, heavy citations on the standing issue. See, generally, their motion support. Well, take their word for it. You can go look at it on the bankruptcy docket on Court Listener, one of the best resources ever. Please, if you have a Pacer account, contribute to it. It's awesome. Because having to pay for stuff on Pacer is a pain in the fucking ass. It's the one. Okay, yeah. Well, that's in case we need a reference back. Okay. The case established principle of black letter corporate law that a corporation holds no property interest in stock owned by its shareholders. The principle does not depend on procedural posture. It applies equally in a fraudulent transfer case, a plan confirmation dispute, or as here, a Rule 2004 discovery dispute. The trustee offers no contrary authority or reason why this court should depart from settled law. Second, the trustee conflates two distinct concepts: her authority to investigate the debtor's financial condition with her purported authority to investigate third-party trading activity. But Rule 2004 is clear that an examination may relate only to the debtor's liabilities and financial condition. The debtor's books, records, transactions, and assets, not the trading activity of other market participants, for which does not in and of itself reveal anything about the debtor's financial condition. The trustee attempts to bridge this gap by arguing that the debtor's financial condition can be affected by third parties' stock trading. This assertion fails at every level. The trustee does not explain how third-party trading in the secondary market could affect the debtor's financial condition. If she couldn't make that argument, I kind of think her lawyers are kind of shit, to be honest, because it's a very easy argument to make. If there's downward manipulation on the stock, that means downward pressure, pushing the price down, that affects the value of the shares that I could sell into the market to, fund the company. And as we know, with all these shitcos that make no money and usually no revenue, have no earnings, then selling your stock is the product. Getting schmucks in equities markets to buy your shitty security is the product. So that's the argument you can make there. It doesn't make you look good, but that's the argument. That's the argument there. That's the only argument you can have. And it's better than no argument. You can at least, make an argument that there's a discovery interest. Try and hold together your flimsy argument, but who cares, right? She also does not establish that any such effect actually occurred here. Even if she could show both, she does not explain what role the non-parties played in any such alleged activity. That's another key part. And were the trustee to provide such an explanation, that third-party stock trading would still need to give rise to claims that are property of the estate, which is defined as all legal or equitable interests of the debtor in property. A debtor has no legal or equitable interest in shares owned by third parties. Stock trading among third-party investors belongs to those investors, not the debtor. The The trustee cites no authority holding that secondary market trading activity implicates estate property, or that a trustee's duty to investigate the debtor's financial condition extends to third-party trading in the debtor's stock, and there is none. Instead, the trustee repeatedly cites NRE Mastro. Wonder if we can go find that. Let's see what we can do, because I want to know what they're citing out of curiosity. Let's see if we can get it off case mine. If we can't, oh well. NRE Mastro. Go away. To identify and collect the assets he requests in order compelling Mastro to sign a consent decree, a rara avis in the bankruptcy world. Rare bird. He intends to send the executed documents to international banks and finances in an attempt to identify and disclose Mastro accounts. Mastro opposed issuance of the consent decree and vehemence and opposed successful. Parties provided little background information for this 2009 involuntary bankruptcy case. Did the bankruptcy court abuse its discretion in denying the trustee's request for an order compelling the consent decree? We review the bankruptcy court's legal conclusions de novo. As most appellate courts do, the trustee advances several theories supporting his request that the bankruptcy court compel Mastro to sign the consent decree, a directive. On remand, the bankruptcy court may exercise discretion. The bankruptcy court decided that it lacked the authority to issue the consent directive. The trustee asks us to reverse the decision and order Mastro to execute the consent decree. But in conclusion, that the bankruptcy court could compel Mastro to sign a directive does not mean that a consent directive should be issued under the present facts. We leave that discretion. Okay, so they reversed the lower court and said the bankruptcy court's discretion is at least threefold. Should the 2004 consent directive order issue, and how long should it issue underlying the bankruptcy case? The bankruptcy court denied the trustee's motion because it thought that it lacked the authority to compel a debtor to sign the consent directive. Well, that seems a lot different. Third parties are not a debtor. just gonna throw that one out there. Just throwing darts at the board. Those two things are a little different. Maybe just a little. But that case explicitly limits the scope to in the very next state, saying that, that the examination may extend to third parties who had dealings with the debtor. And it's right there in the conclusion, too. Here, the trustee does not identify any dealings between non-parties and the debtor to support her subpoenas. This is critical and dispositive. This is a critical and dispositive distinction. Under the trustee's reasoning, any public company bankruptcy would authorize the investigation of the entire securities market. That is not the law. Third, the trustee now asserts for the first time that secondary market trading of public shareholder stock bears on estate administration. What? But she offers no explanation how trading activity among third parties relates to administrating the estate, and cites no authority in support of this new position. Or could she? Administration of the debtor's estate is a term of art limited to issues such as the selection and removal of a trustee, or distributing the property of the estate. The trustee, I mean, it's the same as if you were a trustee of a estate upon death of a person or something like that too. Oh, here we go. Back to my favorite, Sorrento Therapeutics bankruptcy. This is the song that never ends. Yes, it goes on and on, my friends. The trustee's principal authority in RE Sorrento Therapeutics only refutes her new argument. In that case, the debtor owned a 52% equity stake in a subsidiary. Oh, that whole thing was a mess and just another level of ridiculousness. At some point, I should just re-upload all the Sorrento Therapeutics videos that I had done previously on that bankruptcy because that whole thing was a mess. And the Rule 2004 subpoena sought to identify the shareholders to ensure proper delivery of proxy materials for a meeting directly affecting the debtor's investment in the subsidiary. In contrast, what the trustee seeks here is discovery into trading activity by unrelated market participants in securities that were not the property of the debtor for the purpose of developing litigation theories against those same parties. Sorrento confirms the limited meaning of the estate's administration. It does not create an exception. Finally, the trustee's supplemental opposition does not even mention, let alone attempt to explain, how she could purport to seek discovery concerning MMTLP and Torchlight, two entities that are not metamaterials. One was spun out, and one is what Torchlight became metamaterials. So, like, this is the same. Like, can I get a different color here? Yeah, like this. Okay, so I have to delete that one first. So, like, this is what Torchlight became. Totally different. And this, get a different color here. And this was spun out into a new company. So, like, you can't, like, there's nothing there for you. Like, these things have nothing to do with the current estate. So, these securities ceased to exist years before the bankruptcy petition, and the trustee also disclaimed MMTLP. Yeah, much to the chagrin of Scott Trout's buddies. Where the trustee demands and the subpoenas are focused on securities that she does not even argue could even be properly of the estate. The trustee cannot meet her burden to show good cause, and the subpoenas should be quashed as to such demands. Rule 2004 does not permit discovery of untethered from estate-owned claims. Trustee lacks standing to bring claims that are not property of the estate. Didn't we kind of go over this? Trustee's standing problem is not merely theoretical. She admitted it. I mean, that's pretty damning. Pick a little bit of a darker color. Let's get rid of that. Yeah. Better. This admission is dispositive. Because the debtor could not have sued the non-parties on behalf of its own shareholders, neither can the trustee. The trustee attempts to escape this conclusion are unavailing. First, the trustee conflates the general proposition that the trustee may bring securities claims with the specific question of whether this trustee has standing for these claims. She makes the abstract assertion that trustees can pursue securities fraud claims, but no one disputes that a trustee can pursue securities fraud claims to the extent that the debtor itself could have pursued such claims. Again, bringing us back to the whole, it's constrained by what the state could have done when it was a functioning company, which means that if the issuer, MetaMaterials, sold securities itself, then potentially you had limited claims in those limited instances. Or things like swing trading could be brought on behalf by the company or on its behalf by shareholders, whichever. The trustee badly asserts that 2004 is a proper investigatory tool for third-party transactions involving property not owned by the debtor, including secondary market trading of public shareholder stock. But this assertion finds no support in the text of Rule 2004. For example, in R.E. Citizen, the issue whether 2004 permitted a debtor to take discovery from participants in third-party litigation involving claims it does not own or defenses it will not assert simply because the outcome may affect the value of the asset the debtor owns. Just as here, the Sundis sure. Court requested supplemental briefing on this question, but the trustee was unable to cite any authority to support their use of Rule 2004. The court went on to deny the motion for a Rule 2004 subpoena for good reason. To accept this theory would be to permit any company trustee to investigate the entire securities market. Yeah, that's kind of like we're kind of going over ourselves again here. In pari delicto, we kind of went over that last time. I don't want to go over that again. The trustee lacks standing for market manipulation claims. Identified court recognized the burden for establishing good cause. The information is uniquely within the debtor's possession, and the very court issue the court directed the trustee to confront to aid its determination as to whether discovery is proper or instead constitutes improper harassment. The trustee has had every opportunity to answer that question, yet has not done so. So her litigation team she and her litigation team were appointed more than 18 months ago and have been investigating possible securities litigation since August 2024. Her counsel has had access to the debtor's records, engaged in extensive dialogue with the debtor insiders, and conducted a pre-petition investigation into these very claims that yield extensive documentation. The trustee is thus uniquely positioned to answer the court's question of whether and when the debtor was a seller, and tellingly, she has not done so. This is the big problem, because this was pointed out, and I think is about to be pointed out, is that all of their securities offerings were at fixed prices. So the alleged market manipulation couldn't have affected the price. Critically, discovery from the non-parties cannot supply the missing facts on which the trustee's standing depends. Whether and when the debtor sold its own securities is a matter uniquely within the debtor's possession and control. Yeah. Rule 2004 does not permit a trustee to compel discovery from third parties without evidence that those third parties have unique information that the debtor does not. While the trustee asserts that there is evidence that the debtor has sold shares, she does not supply any such evidence or explain how it would support a proposed claim even if she provided it. All the trustee has offered are prospectus documents dated from 2024 that do not establish that such sales were ever actually consummated. So they're, oh my goodness. What? Oh my goodness. That is pretty fucked. Oh my goodness. Ouch. That's pretty damning. But even assuming any such sales occurred, the prospectus materials undermine rather than support the trustee's theory. Exhibit 1 to the supplemental opposition reflects that debtor agreed to sell securities at a fixed price below the then prevailing market price. Oof. This whole bankruptcy proceeding is fucking embarrassing. Oh my goodness. This whole discovery shenanigans, I believe, has been a giant tactic by Wes Christian to try and expand his burgeoning empire of filing frivolous fucking lawsuits. And that's why this is all very like slipshod. He's trying to find a way to abuse the system so that he can file and make money off the frivolous lawsuits that he loves to file about naked shorts and all these the fucking spoofing claims. The magical lines go up and down in the wrong way that I don't like. So we're about to get into Northwest Biopharma, but I had another point on this that I have a feeling that the GNS thing that they want to get they like the GNS is the next step in Wes Christian's little scheme. I personally don't think that a company has the ability to be a class to have a class action lawsuit and to be lead plaintiff, because it's not similarly situated with the rest of the shareholders. It has entirely different claims. And on top of that, how it issues shares is completely different and dilutive to the rest of the class. So they can't be the same. There's no way. But like, it's another step in Wes Christian's scheme, because if he can establish that a company can file a class action lawsuit and be lead plaintiff in a class action, spoofing lawsuit on behalf of its shareholders, then you can go to the bankruptcy court now and file this whole scammy fucking 2004 discovery and say, look, we can represent shareholders. Look at this GNS lawsuit and how we were lead plaintiff in this whole thing, and now we can go about and rummage through everyone's fucking garbage with 2004 discovery. Like, all of this is connected. It's why, and I said it back when I covered Sorrento on my old channel before it got nuked. I said he was using the bankruptcy proceedings to be able to find some way to screw around with the fucking bankruptcy rules so that he can use that to proliferate his shady fucking practice. And a year later, here we fucking are. Fuck you, I was right. Fuck you, I was right. Fuck you, I was right. Anyway. The trustee own exhibits therefore negates the asserted theory of harm. Second, the trustee relies on Northwest Biopharmaceuticals, B. Kennard Ginley LLC et al. For the proposition that issuers have standing for market manipulation claims, but this authority confirms she lacks standing here for two reasons. As an initial matter in Northwest Biopharmaceuticals, the court granted the initial motion to dismiss because the plaintiff had not plausibly alleged a specific connection between its own stock sales and the purported market manipulation. Oopsies. After plaintiff amended to allege a formulaic connection between its stock sales and the alleged market manipulation, the court granted a subsequent motion dismissing in large part the alleged sales, except for a limited number that were on specific days linked to alleged specific manipulation. Despite ample opportunity, the trustee has not even attempted to show any connection with respect to its own purported sales of stock. That didn't work. Let's try it again. Indeed, she cannot, as she has failed to establish whether and when the debtor sold any stock, let alone its sold stock at prices affected by significantly connected to the alleged misconduct. Moreover, in Northwest Biopharma, plaintiff, which was represented by the same counsel as the trustee here, filed with its complaint an exhibit identifying its own specific sales allegedly affected by market manipulation, including the number of shares sold, the price, and the date, all obtained without discovery. This is another key thing about discovery, period, whether it's 2004 discovery or it's, Rule 45 discovery. If it's redundant information, you don't need it. You already fucking have it. Which, proves the point that, Citadel and Virtu, and Anson is making, is that this is just to harass and otherwise try and shake down people who they plan to more than likely sue anyway. So, like, this is just a shakedown to harass them. And a lot of the information that is being asked for is information they already have. Third, the trustee lacks standing for a market manipulation claim because she cannot establish an assumption of an efficient market free of manipulation. Yeah, that's a big one here. So there is the efficient market theory, and the efficient market theory assumes a market free, an efficient market, first of all, which means that most of your OTC shitco stocks don't qualify for the efficient market theory because they don't operate in an efficient market. They in fact operate in a very illiquid, inefficient market with no one reporting on their securities, and also in a market where a lot of them aren't even they don't do regular SEC reporting. Like, they're still regulated by the SEC. All securities are regulated by the SEC, but they're so small, or they have so few shareholders, that they don't meet the requirements to have to report as a public company to the SEC. So a lot of these shitcos, like the really shitcos, can't use the efficient market theory. But the other part of the efficient market theory is that it is a market free of manipulation. If the market is already being manipulated by some other thing, then you can't avail yourself of it. That's how that's how Ryan Cohen escaped back out the back door on the market manipulation claims in the Bed Bath and Beyond lawsuit against him. That you can't argue the efficient market hypothesis if you're in the middle of a short squeeze. By definition, a short squeeze is an inefficient market. Therefore, it's a lot more complicated to prove market manipulation in that case. As the non-parties explained in their opening supplemental brief, the debtor's payment of millions in settlement concerning its own market manipulation negates reliance. The trustee's opposition is silent on this point, which constitutes waiver of any argument to the contrary. Yep. If you fail to defend an argument, it's considered waived, that you've given it up. Finally, the trustee's assertion that Rule 2004 discovery may reveal other claims only underscores that the trustee's theories are wholly speculative. Rule 2004 does not permit discovery in the hope that it may someday reveal a viable claim. Moreover, each of the additional claims the trustee now gestures towards such a professional malpractice would necessarily depend on some direct relationship between the debtor and the non-parties, yet the trustee has not identified a single relationship. The trustee has not established that the debtor was a seller, has not shown it sold stock at prices affected by the alleged market manipulation, and has waived any argument on efficient market reliance. The trustee has not shown good cause for 2004 discovery, and the subpoenas should be quashed or a protective order issued with respect thereto. The subpoenas constitute harassment and therefore lack good cause. It is well established that Rule 2004 subpoena may not be used for the purpose of abuse or harassment. That is, it must be relevant and reasonable, and may not be used to annoy, embarrass, or oppress the party being examined. The trustee has never articulated a valid reason for seeking discovery from the non-parties, leading to the unavoidable conclusion that the purpose is harassment. Discovery from the non-parties cannot supply the threshold missing link. Communications, trade data, and position information maintained by third-party market participants have no bearing on whether and when the debtor sold its securities. And while the trustee asserts in cursory fashion that she does not have full knowledge of the debtor's financial condition, she makes no argument as to why the non-parties would be able to fill a purported knowledge gap. At the same time, she is seeking market-wide transaction information from other subpoena recipients including FINRA and NASDAQ. Accordingly, the trustee asserted a lack of knowledge does not justify subpoenas. Rather, it confirms that the requested discovery is untethered from the estate's property and directed instead at harassing third parties in the hope of someday identifying a viable securities claim for shareholders. Rule 2004 does not permit that use. The trustee's counsel has already filed claims. She says she cannot plead without discovery. As the party explained in their opening supplemental briefs, the same law firms retained by the trustee have already sued certain non-parties in multiple federal courts, asserting identical manipulation theories based exclusively on publicly available data. Okay, we got that one. The subpoenas are overly broad and untethered from their purported purpose. The trustee's shifting description of her own subpoenas is further evidence of harassment. She now characterizes her request as seeking merely targeted data sets of metamaterials trading data and related communication. I love that they give us this chart here of how the storyline has fucking changed over time. First, it's subpoena at ECF no or electronic certified filing, or docket no 2088-1. All messages relating to the routing of orders of any type of shares for metamaterials or MMTLP, all communications including transactions records and emails, all records of position data representing each non-party's position in metamaterials or MMTLP. Then on July 17th, 2025, in the meet and confer correspondence, Motion Exhibit 8, non-party could mostly satisfy its discovery obligations in response to the subpoena's request by generating and producing spreadsheets of relevant trading data. Then the trustee's opposition, ECF no 2206. The subpoenas seek only 4 years of trading data specifically to metamaterials. And then we get the opposition that most recently was filed. The trustee seeks targeted data sets of metamaterials trading data and reliance and communications. Notice how, as she gets held to the fire on these issues, it gets narrower and narrower and narrower as she realizes that, 2004 can't do what she wants it to do. While the trustee's position has shifted, the subpoenas have always, on their face, demanded 4 years of proprietary trading data, communications, order routing messages, highly confidential internal positions records, and stock documentation across the 3 different securities. There are wholesale demands for confidential business records from non-debtor, non-creditor entities concerning trading activities in secondary markets. The burden of searching for, reviewing, producing such voluminous materials is substantial and must be weighed against the requesting party's legitimate need, as it is in Rule 45 discovery. Like, discovery, as someone who's had to deal with discovery, thank you, Bill fucking Pulte, is pretty broad as it is, but there are still limitations. You don't get to just ask for anything and everything and violate people's privacy and waste their fucking time. You need to have specific things you're looking for, and it needs to be reasonably related to the matter at hand, which makes this even harder that we don't have a case that we're looking at. They're just going on this random fucking fishing expedition with what seems like no purpose because they refuse to reveal what the purported purpose is. It's an absolute clusterfuck. The trustee has full access to the debtor's records of personal. I think I went over that. In conclusion, the non-parties respectfully request the court quash the subpoenas in their entirety. Abject silliness. I really think that our friend in the comments there, Daniel, I think put it best that this whole thing is an errand in futility. It's pathetic and it's absolutely dumb on its face. Okay, for a moment, I just. This is baggy kryptonite. Yeah, yeah, proven. Absolutely true. Platinum is baggy kryptonite, and they absolutely hate that she wrecks every stupid thing they say. And she doesn't even really have to try either. It's not like it's a hard task. Before we go, I kind of want to see if I can find this dumbass fucking baggy stream that just we're not gonna play it right away, but in case I have time, I make it to it. But man, oh man. See here, I'm trying to find. Oh, there. I'm sure he should have the bingo. Or I guess not. I thought he would have it if he was in it. What if? Oh, there it is. How long is this stream? 3 fucking hours? Oh. Oh no. Dear me. Well, see, this is why I don't listen to like fucking streams, because they're just they are like these space calls, are they like just no, they're too long. So this, before we move on to our section where we may need the heavier alcohol of choice, um, is the order from back on from the hearing date back on October. This was filed last week. I missed, and this was the order on motion to disqualify Christian at her firm and West Christian. On October 16, 2025, the court held a hearing on the motion by Scott Troud to disqualify West Christian and his law firm. Scott Troud, the pro se individual who filed the motion, is an investor who in 2022 purchased 305 shares of Metamaterials in the above captioned debtor. Mr. Troud has described himself as a third-party intervener. Ooh, my goodness, the shades of the AMC lawsuit. I'm starting to have fucking Vietnam flashbacks when I see the word intervener. While under certain circumstances, a party in interest may intervene in an adversary proceedings initiated by a chapter trustee, there is no opportunity for a third-party intervention into the main bankruptcy proceeding. Well, I'm glad we shut that down. Last thing we need is a whole army of meme stock pro se sob sit interveners. Just Mr. Trout seeks entry of an order disqualifying special counsel Christian Adder in the debtor case. That said, his purported investor, holder, and debtor, Mr. Trout, may move the court for relief. Good. Glad we don't have to deal with that intervener shit. Just let him do his thing. Just let him do his thing. The order authorizing. Wait, Scott had only 350 shares and he's on a crusade? Yeah. Oh. Yeah. Oh, yeah. You think that's bad? You should have been there for the whole AMC thing. Like, I bet a bunch of them bought at the top. How do you think it got bid all the way up to, what was it, like $12 in MMAT or something like MMTLP? I mean, like, yeah, I remember back to the AMC lawsuit. A bunch of them accidentally posted unredacted or just posted because they thought that's what they had to do, their proof of share ownership, and like fucking a bunch of these people had under 100 shares and they were all top tickers. Like, they bought AMC at 50, 60, dollars a share, all the way up there to the top. And so they didn't have a whole lot of shares, and they still don't. Like that's what happens. Like the momentum starts building, and all these people who go on these baggy crusades, they bought at the tippy top. They don't have very many shares, but they lost everything. Fucking everything. Being an idiot. According to the ex parte application by Chapter 7 trustee to employ the law firm, Christian Adder was employed to investigate the potential claims and pursue litigation related to the suspected stock manipulation through legal trading practices such as naked short selling and spoofing. In summary, the potential litigation attached to the application the Chapter 7 trustee disclosed. The Chapter 7 trustee has argued that Mr. Trout lacks standing to bring motion because in December 2022, his MMTL shares were automatically exchanged for Nextbird Charter Carbon shares. Accurate. Formerly a wholly owned subsidiary of the debtor, who is now an independent company and whose shares are not publicly traded. So this appears to be supported by Mr. Trout's own account and statements from his TD Ameritrade attached as proof of interest. To date, the Chapter 7 trustee has not objected to Mr. Trout's proof of interest. Absent objection of a proof of interest is considered prima facie valid. I.e., if someone... Hey, Ethan! Unless you object in the proceedings, a proof of interest statement is considered prima facie fact. I'm sorry, I had a little bit of a moment there. Mr. Trout alleges that Christian attorney Wes Christian must be disqualified from serving as a special litigation counsel to the Chapter 7 trustee for a litany of reasons. And these reasons for disqualification include Mr. Christian's representation of NBH in a state court litigation involving Mr. Trout and other purported shareholders conduct in a non-bankruptcy litigation, reported failure to provide the Chapter 7 trustee with solid data, litigation against pro se individuals, and frequent firm changes. In the application, the trustee sought. From a review of the briefing, it does not appear that Christian Adder has an economic interest that would lessen the value of the bankruptcy estate or create an actual potential dispute at odds with the estate. Rather, Mr. Trout appears to argue that Christian Adder holds an adverse interest in the debtor based upon the third option, possessing a predisposition under circumstances that create bias against the estate. What? But simply, Mr. Trout's allegations of bias against Mr. Christian do not implicate the bankruptcy estate. NBH, previously a wholly owned subsidiary of the debtor, is currently an independent company with no evident ties to the debtor or the estate. Mr. Trout has further failed to explain how Mr. Christian's litigation with pro se individuals is adverse to the interests of the bankruptcy estate. Mr. Trout has not indicated that Mr. Christian is pursuing any state court litigation against the estate. In fact, Mr. Christian represented the debtor's pre-petition, a circumstance which might demonstrate bias in favor of the bankruptcy estate. Finally, Mr. Trout has not developed a persuasive argument regarding Mr. Christian's firm's changes that would indicate a bias against the estate. The court recognizes that across 3 separate declarations, Mr. Christian continues to add disclosures which expound upon his statement in support of employment originally indicated he held no interest adverse to the bankruptcy estate or its shareholders. The duty to disclose is an ongoing obligation. Get a citation. Although there's no ongoing disclosure requirement, especially set forth in 2014A, as is the case with Federal Rules of Bankruptcy 2016B. Case law has uniformly held that under Rule 2014A, 1, fully disclosure is a continuing responsibility, and 2, an attorney is under the duty to promptly notify the court if any potential for conflict arises. Mr. Christian has continued to disclose. Continued disclosures do not warrant his disqualification. However, it should be determined at a future date in this case that Mr. Christian or Christian Adder do hold an interest adverse to the estate, provided for the disallowance of compensation in the event at any time during such professional person's employment under Section 327 of for these reasons, it's hereby ordered that the motion by Scott Trout is denied. And of course, send a copy to Scott. Oh shit. I'm not in the. I'll go fucking edit that later. I'm not in the interest of accidentally doxing him. I know he put his name on a public document, but still, I try not to be too much of a douchebag on things like that. So I'm going to take a brief break to refill some water, and then we're going to get into some really silly stuff. All right, folks, we're at the point of the show where we're going to go full sob set. Full sob set. Danielle Spears. Oh, trying not to be too much of a douche, but this is pretty bad. This stuff I think is Project Popcorn level dumb. Generally, Scott's crew is usually not Project Popcorn level assholes on the internet. We'll give them that. They don't dox people. They don't usually threaten to harass people. They can still be douchey at times, but hey, I'll take what I can get. However, these two filings are just straight up dumb. They're just straight up dumb. There's no way to put it. I generally, my hope usually starts on a sliding scale. Excuse me for a second. We're going to go full screen here. Usually I'm on a sliding scale here where when you have baggies do filings and it looks like they're going down the right path, I generally am like, good. Expressing your shareholder rights, totally fine. Going about trying to figure things out. And, Scott's group is at least halfway right, at least going after the right people right. Going after, Greg McCabe and John Berta and, George Palicaris, the actual scummy scammers in this whole episode. But they, much like the Project Popcorn crew, they still want to keep their naked shorts, evil market manipulators, conspiracy theories. They want to have their cake and eat it too. Which is my problem with them. And it's the same with Project Popcorn people. They want to, claim market manipulation, all this stuff, but don't want to read any of the fucking financials. They don't want to understand why the company had to do what it did and did what it did and all this stuff. And it's just, and usually I'm okay with that. If it looks like a person is willing to learn, like, me and, what's his name? It's been a while because I think he doesn't really do YouTube videos anymore, but, Bubby, I'm sure it'll come to me later, but it's late. Like there's some AMC no voters that I agree with, because as the process went along, they made it very clear that they were willing to learn and understand the stock market. That you know, you know the like that they were willing to learn. When people have made it clear that they're unwilling to learn, then I just start making fun of them. Cause like at that point, it's like, you spend all this time and it's like, one step forward, four steps back. And it's just, they just don't want to learn. They don't want to learn. They want to be coddled by their conspiratorial view of reality. And I just done. And this is an example of that. This is new silliness. This one wasn't so bad. The other one was the thing that was really dumb and bad. Oh yeah, we'll get to that. This one was not so bad. This is a normal thing that people usually trip up on. So this one isn't so bad. Movement Danielle Spears, appearing pro se, respectfully moves this court for a determination of her standing standing in the court. Jurisdiction, factual background, not too concerned. Legal standards. Standing in bankruptcy is determined more broadly than in ordinary civil litigations. Courts recognize standing for parties who hold direct, contingent, or potential interests that may be affected by the outcome. Yep, due process requires notice that is reasonably calculated. Yeah, we are going to shit. I forgot to get this. I can highlight it and stuff. That reasonably calculated, that word there is going to be very key. The reasonably calculated part of this. To apprise interested parties of the pendency of the action, a bar date cannot constitutionally bind parties who are known or reasonably ascertainable but were not provided adequate notice. Movement has standing as a contingent equity security holder and as a party interest. Movement does not contend the status of holders of MMTL securities have been conclusively adjudicated in this case. Rather, movement asserts standing based on a contingent equity interest arising from the disputed spinoff transaction that purported to cancel MMT securities. It wasn't purported; they were canceled, and replace them with the interest in NextBridge hydrocarbons. The Bankruptcy Code expressly recognizes contingent, unliquidated, and disputed claims, but there's nothing that's being disputed. Where the validity or effectiveness of the transaction that purportedly eliminated equity interest is itself disputed. It's not disputed, though. Affected holders possess standing to be heard to prevent forfeiture of rights without due process. Courts routinely permit parties asserting a contingent equity interest to participate where resolution of disputed transactions may restore those interests. And no. There is no may. There is no restoring those interests. They're dead. Here, Movement and other holders of TLP securities contend that the spinoff transaction was fraudulently structured and or improperly executed. If the transaction is deemed to be void or voidable, it's a little fucking late for that. If you thought that was the case, you should have been in the courts way long the fuck time ago. It's like nearly 3 years. No, it's 4 years almost. I mean, it's 3.5 years about almost. So that transaction happened in 2011. So, I mean, coming up in March, it would have been 3.5 years. Like, too fucking late. Like, that's the other thing these people don't understand is at some point, your claims are voided. These things don't go on into perpetuity. Here, Movement and other holders of MMTLP securities contend that the spinoff transaction was fraudulently structured and improperly executed. That term to be voidable. Nope. The potential restoration. Nope. See what I mean? We're going to need some alcohol to get through this. The trustee has acknowledged uncertainty regarding the notices of the equity interest holders without specifying whether that uncertainty was limited to MMAT common shareholders or extended to holders of MMTLP securities. That ambiguity further supports movement standing to seek a determination of notice adequacy and bar date enforceability before rights are extinguished. Rights never existed, my. In addition to asserting contingent equity standing, movement has taken affirmative rule compliant steps to preserve her rights. In this case, movement filed proofs of interest relating to MMTLP securities. Movement also filed proof of claim on an official Form 410, which was entered December 16th, 2025. These two filings were made out of abundance of caution and without waiver of movement's position that her interests are properly characterized. Well, I mean, then what fucking discussion are we having here? Notice was provided was not constitutionally adequate. Trustees' admission that she could not be certain that all equity interest holders would receive notice establishes that the holders of MMTLP securities were not purely unknown creditors in the Mullane sense, but rather constitute a large identifiable class whose entities were reasonably ascertainable, even though they exercise a reasonable diligence. When a debtor or trustee knows a large group of investors exists, but asserts difficulty in identifying them individually, due process requires supplemental methods of notice, including publication. There was an SEC filing. What do you mean? There was publication. Oh, Jesus Christ. Or representative procedures. Here, the mailing matrix reflects 1,549 listed names and entities, many of which are intermediaries, professionals, or institutions. The matrix cannot reasonably represent the thousands of. Oh my goodness, we're having that discussion again. The stupid fucking postcard notice from the AMC lawsuit. That's what we're doing. That's what we're fucking doing. Christ. We can resolve these arguments similarly. First, concluding that the hearing would not have entered the fact that the opt-out deadline passed before they received notice. Failing to continue the hearing was not an abuse of discretion because heirs would still be bound unless the opt-out deadlines were extended. Second, even though it would be an error to rely solely on notice by publication, this is not what the district court did. Rather, it said that the mailing of over 6,000 long-form notices as well as publications constituted the best notice practicable. Best notice practicable. We went over this. Like, this is one specifically from the Ninth Circuit, which was what Nevada would be in. But, like, when you own something in street name through your broker, and your broker is noticed, it's considered good notice. That is considered good service for intensive purposes. And I know this is, you're gonna say, noisy. This is from a settlement case, yeah, but it's the same process. It's the same blast notice that is used across the board. Noticing your broker, if you hold in street name, is good service. If your broker fails to deliver, then sure, you might have claims against your broker, which I'm pretty sure is in here. There we go. Finally, while Chief Judge Real did not comment that Arias had got a problem, did comment that Agrias has got a problem with his broker and may have a lawsuit against his broker. Like, if you don't get notice from your broker, then go sue your fucking broker. But like, you got notice by the legal definition, and you did, like, it is constitutionally adequate. Sorry. And yeah, so the bar date can be enforced. Broadridge shareholder position data is relevant to notice and notice identify. Because the trustee has acknowledged uncertainty regarding notice to equity interest holders, and because the record contains inconsistent and non-specific representations regarding the number and entity, like some cite, like, could we cite to what she said? Can we get a quote? Can we stop this trust me bro stuff? Can we cite to where she said this, please? I hate trust me bro filings. Can we get a quote as to what she said? Can we cite back to where she said it? We got that during the stuff that, you know, Virtu, and I get the argument's going to be she's pro se. She's not she's not she's not a professional lawyer. Yeah, well, this isn't her first fucking rodeo. Having to deal with people who do this on a constant basis, just I lose a certain amount of oh well, I mean, it was a mistake. It's like, no, you are filing in a court. You have the same responsibilities as a lawyer. Act like you do. Make it easy for you to follow the argument. Understand what you're citing. Like, stop being so soft-set. Like, maybe they aren't exactly soft-set in the traditional definition, but like, it's above and beyond like normal pro se just stuff. Like this filing. Oh, take a shot if. I probably shouldn't turn this into a drinking game. It'd be very bad. This entire filing, I hate. And I hate for very specific reasons. I hate when people think that they can play cutesy games with the court. Or because a judge is being nice to them that they can play cutesy games. And that's what this entire filing is. It is a cutesy game. I'm not accusing someone of something, but man, this is really suspicious. It's your standard conspiratorial, I'm just asking questions, bro. I'm not accusing anyone of anything. I'm not saying anything's factual. I'm not saying I even believe it. I'm just asking questions, bro. Hate it. Hate those kinds of arguments. Stop it. When a court tells you something, don't find cutesy fucking ways to keep making that argument. Anyway, introduction, movement, Danielle Spears. Appearing pro se respectfully, I seriously contest that, files this motion pursuant to requirements that request for the court's action be presented by properly noticed motion. Yeah, and when you file a motion, you need to actually file evidence the thing you're... Let it go for now. This motion seeks limited, non-merits threshold determining clarifications of the court record concerning discrete issues referenced in those docket entries. Now presented in a procedurally proper posture permitting supervisory determination. No. These materials are cited solely to identify the existence of factual materials already filed in the docket. No prior request for relief is renewed. What is it? And this motion presents the issues in a procedurally posture permitting supervisory determination. You're saying that you're not arguing in the posture of requesting relief, but you're asking the court to invoke its supervisory role on these things that you're just asking questions about. Just asking questions, bro. This motion does not seek reconsideration of any prior rulings. Just asking questions. Does not request relief previously denied, including a reset of the bankruptcy administration, appointment of neutral... You know. Incorporation of prior submissions. Yeah. Compliance with court-directed meet and confer. At the hearing, the trustee's first interim application for compensation, the court directed movement to confer with the trustees' counsel regarding the issues raised and advised that any matters not resolved through the process should be presented to the court by motion if ruling was sought. Movement complied with the instructions and participated in a conference with the trustees' counsel. Trustee Lovato did not attend the conference, and discussions of several materials issues could not be completed or substantively addressed. Certain topics were deferred or left unresolved, despite movement's good faith effort to raise them, and no follow-up responses or clarifications provided afterwards. Accordingly, movement now files this motion seeking judicial determination and clarification of these unresolved issues. Oh my goodness, factual background. I'm really good. I'm good. FINRA self-revised the meta corporate action. It fucking did not. FINRA's public admission regarding remaining short positions in the abundant and not relevant to the bankruptcy. Regulation not relevant to the bankruptcy. Preparation, retentions, and public investigation following the FINRA U3 trading halt, pursuant to which MMTLP was halted until deleted. Various non-debtor entities, the debtor issued public statements concerning preparation. Claim third. I'm not sure what that has to do with bankruptcy, but cool. Post-petition retention and recording is inconsistencies following the commencement of this Chapter 7 case. Trustee retained Mr. Christian as special litigation counsel and made representations to the court regarding investigative scope data acquisition related to MMAT and MMTLP and related federal litigation involving NBH. Mr. Christian moved to withdraw as counsel for NBH on the stated ground that there was good cause due to a potential appearance of conflict of interest, identifying the source of the potential conflict as his role in special litigation for the Chapter 7 trustee in the bankruptcy, while representing people that would probably be targets of the trustee, namely McCabe and Berta and stuff like that. The record does not clarify what disclosures, if any, were made to the court or parties in interest regarding the overlap between Mr. Christian's representation to MBH and his court-appointed role for the estate. That's not required. In a sworn declaration by Mr. Christian on or about June 17, 2025, in a separate litigation, Mr. Christian stated that his consulting experts were engaged and that he, co-counsel, and at least 5 related experts attempted to obtain records intended to prove market manipulation involving Meta and MMAT. He further stated that those efforts were unsuccessful because sufficient evidence cannot be obtained and subpoenas cannot be issued absent the filing of a lawsuit, and that corporate cooperation could not be obtained from multiple organizations without subpoena power. The June declaration does not identify the experts retained. Scope of the dates of their work, the specific securities investigated, the entities from which the records were sought, the nature of the records requested, who funded or authorized these engagements, who had any resulting records, or whether the trustee was made aware of these deals, thereby preventing verification of the declaration. This is all work product privilege, all work product, attorney work product. Like, unless you can prove there's a reason, this is the thing. This is why I continue to say that this is, I'm just asking questions, bro. Like, all of that are fine questions. If you can actually point to something that was done that was improper, simply posing the question and going, that seems suspicious, the court's going to be like, okay, and it seems suspicious. Like, what do you want? What do you fucking want me to do about it? Like, unless you can actually show where it's suspicious, what about it is suspicious? Substantiate its suspiciousness. Just simply going, well, that seems weird. What do you fucking want the court to do? In the same declaration, Mr. Christian stated that under authority conferred on the trustee pursuant to Federal Rules of Bankruptcy Procedure 2004, he and co-counsel subpoenaed more than 10 entities in connection with the investigation. The docket reflects notices of issuances for 9 subpoenas, entities prior to August 21st, 2025, including an amended subpoena issued to Virtu. The record, however, does not disclose which subpoenas resulted in documents. Again, This is attorney-client privilege and work product. Fucking Christ. This would all come out in litigation and would be presented in a trial, but like the lawyer has no obligation to tell anyone but their client, which would be the trustee. And like if the court really deigns to know, they'll ask. But this is all attorney-client and work product privilege. Like you're not getting any of this shit. Just for the record. Unless the court specifically wants to know specifics about the progress for reasons. In subsequent sworn declarations dated August 21st, 2025, Mr. Christian stated consulting experts were engaged, that the DTC records were being compared to Broadridge data and corresponding to FINRA was produced, and that preservation letters were sent. Ultimately determined that evidence was insufficient to file claims. Okay. The record does not disclose how DTC and Broadridge data were compared, particularly, like, again, work product privilege, attorney-client privilege. Just because you're a fucking shareholder doesn't mean that, like you have an interest in this. You can make legal arguments and things like that, but, like, the company is an entity, is a sovereign entity unto itself. It's the same reason that if I owned shares of United Airlines, I can't just waltz in there and say, I'm an owner of the company, give me a free ticket, please. Like, the company is its own sovereign entity with its own sovereign legal rights independent of anything else, including its shareholders, including its bondholders. Shareholders have an interest, and that the management is to act as a fiduciary for them because they have an owner, they have like a stake in the company, an interest, but the company is its own sovereign entity. And so when the company or the company's estate, in the case of bankruptcy, hires legal counsel to go do things, they are not obliged to have to fucking tell shareholders a twiddly fucking dick of anything. Because they're the company's legal team. They're not your legal team. They're the company's legal team. Unless you can show some actual verifiable thing that the company's legal team has done wrong, that's attorney-client privilege and work product privilege. You don't get to touch that shit. You don't. Again, just like refusal to understand or learn the law. Share intel, Winger, prior relationships, data custody, access, and disclosures. Trustee retained David Winger and Share Intel at the recommendation of Special Litigation Counsel Wes Christian to provide trading data and analyze on a bi-weekly basis using estate funds. Mr. Winger submitted declarations asserting disinterestedness. That is quite the word. In connection with that retention. Those declarations do not disclose any prior professional relationship with Mr. Winger. He owns Share Intel. Like, this is all, like, already known facts. Like, what are we doing here? What are we fucking doing? Movement attempted to obtain clarification regarding the existence, scope, and custody of investigated. Again, attorney-client and work product privilege. Get the fuck out of here. In subsequent conversations in June 2024, Mr. Winger stated that he could not legally speak, which, yes! Yes! It was regarding the investigation into client. Yes! Because attorney work product and attorney-client privilege. He can't discuss it with you. You're not his clients. Whiskey makes the world go round. In a subsequent conversation in June 2024, Mr. Winger stated that he could not legally speak with shareholders regarding the implication. Yep. The communications reflected that investigation data, if tamed, have been treated as because they are and have been treated as company controlled and inaccessible to shareholders. Yes. And that informal efforts to determine what data exists and who controls it and whether it has been relied upon in representations in court have been unsuccessful? Because it's not your fucking business. Movement wrote and emailed Meta requesting answers. Yeah, you're not. Yeah, no response. Of course you didn't. Like this. Data provenance and funding, firms analysis, metrics, and undisclosed financial and access pathways. That's a weird ass title, but okay, let's roll with it. In the trustee's application to employ special counsel and related litigation funding materials, the firm's analysis is described as identifying 55 million shareholders of MMAT, 92 million church allegedly impacted by spoofing. The record does not disclose the data sources, data sets. The property of the company. Same figures, approximately 65,000 retail shareholders appeared publicly in reference to Torchlight, Metamaterials, and Exbridge Hydrocarbons. The record does not disclose whether these statements refer to a single or continuous shareholder. Well, I mean, company can only know about those that are directly registered. They can ask like Broadridge or the brokers how many accounts they know of that are holding shares, but like it's doubtfully individual shareholders. Like we had this discussion with AMC. I can answer that question for you. It's definitely not. Yeah, it's not. It's definitely like contiguous shareholders. It's multiple accounts and whatever. The record further does not disclose who financed the acquisition or analysis of the data. Again, attorney work product, attorney-client privilege. Public statements and communications in the record indicate that Flamethrower was formed to fund investigation and discovery efforts relating to the alleged manipulation of Torch and MMTLP and related securities, including the acquisition of information. These records do not disclose the identity of Flamethrower's members. Same as above. Attorney work product and client privilege, attorney-client privilege. Movement further notes that NBH. Look, at this point, just file a fucking. Just do a fucking adversarial claim against the estate. Yeah, adversarial proceeding against the estate. Fucking get this information in discovery, but like even then it might be troublesome to get because again, most of this is privileged materials that you wouldn't get even in discovery more than likely. So like you need to actually substantiate a reason why this stuff is suspicious other than it looks suspicious to me. Movement further notes that NBH's capital structure and reporting indebtedness have been the subject of insider-level transactions involving Mr. McCabe, including the reported purchase of NBH notes receivable for a fraction of the face value and subsequent. Like, this is all NBH stuff. Who the fuck cares? This is fucking Metamaterials bankruptcy, not Exbridge Hydrocarbons bankruptcy, though that is coming soon to a neighborhood near you. Absent disclosure of these fundraising arrangements, data analysis pathways, and Broadridge data subpoena scope, unresolved shareholder position reconciliation. Claim register in this case reflects the Broadridge Financial Solutions is a creditor of the estate in an approximate amount. Yeah, because they asked for Broadridge's services and they didn't get paid for them. That would make them a creditor. Despite repeated public and sworn statements that Broadridge's shareholder position data cannot be obtained absent a subpoena, the record reflects that no subpoena was issued to Broadridge, even though Broadridge is the prime because they paid for the data. That they paid for it. That's why that they're an estate creditor. They paid for Broadridge to give them the data. Like, one is here. If you add them together, you get two. Why can you not follow, like, even as you wrote it, like, the evidence of how this came to be is, like, right there. How can you not write this out and then go, oh, and then scribbled it out. The trustee has represented that subpoenas were issued in connection with the estate's investigation of alleged market manipulation involving material securities, including. Yeah, I figured that was going to happen eventually. Darn Twitch bots. Gone. I banned you. Sent you to the netherworld. The records do not disclose what service data, if any, were provided because, again, it is fucking work product privilege. Get the fuck out of here. Yeah, the absence. They didn't need a subpoena. They fucking paid for it. They paid for the information. Broker-dealer record retention obligations are governed by SEC Rule 17A4B and FINRA Rule 4511, which generally require provision of order handling records, consumer communications related materials for a minimum of 3 years, after which routine destruction may occur absent preservation directives. December 9, 2025 marked the expiration of multiple routine retention periods applicable to broker-dealer records relating to MMTLP trading prior to the FINRA U3 halt. December 9, 2022, Movement requested her own books and records from Charles Schwab, which had acquired TD Ameritrade. Schwab produced transactional records and account statements, but declined to produce customer message center communications, too late to cancel orders, and other internal order handling records, stating that such data was no longer accessible following system migration. Schwab further asserted general objections. What is this? What does this fucking have to do with Metamaterials bankruptcy? Who gives a fuck? Control and access investigation data and denial of information to shareholders. Oh, I have a feeling this is not going to get better. Excuse me. Movement attempted to obtain information regarding the existence, scope, and control of trading data and investigative materials relating to MMTP. This is the fucking Metamaterials bankruptcy. Why are we back on this? During initial communication on April 9, 2024, Mr. Reiner stated that he could either confirm or deny the existence of trading data, but indicated that any data obtained by share intel or special counsel was controlled by Meta. Yes, because this was data asked for by the company. It's the company's data. You may recognize this as an attorney-client privilege and also work product privilege. During the subsequent telephone call, Mr. Reiner asked Movement whether she was a shareholder. When Movement confirmed she was, Mr. Reiner stated that he could not legally speak to shareholders. Yep, because it's fucking company information. These communications reflect that the investigation data, if obtained, is treated as company. Yes, because it is. As a result, Movement and similarly situated shareholders have been unable to determine what investigative materials exist and who possesses them. Because it's... Make it stop. Prior shareholder requests for information and failure of informal disclosure channels. While Metamaterials Inc. was still operating as a public company, Movement and a group of confirmed shareholders made formal good faith requests for information directed to the board of directors and investor relations. These requests included a written demand transmitted on or around March 2024 and sought clarification regarding corporate governance, investigative efforts relating to MMAT and MMTLP share issuance, and the status of any litigation or regulatory actions. Despite the scope of specificity of those requests, Movements did not receive any substantive written response. No clarification was provided regarding matters raised, and no alternative avenue for obtaining the required information was offered. Welcome to having shares in a shitco that exists in Nevada. Have you read the Nevada rules recently? It requires that if you want to books and records requests or any sort of thing, Nevada requires, fucking 20-25% of shareholders to be able to legally force the company to cough up this information? Yeah. Of course they're going to ignore you. You decided to fucking have shares in a company incorporated in the worst fucking state in the United States. a literal shitco incorporated in Nevada. Pro tip, if you're investing in the stock market, if you see a company that is incorporated in Nevada, run far fucking away from that company as you possibly can. Do not touch it. Do not invest in it. Do not know it exists. It is a trap. It's a trap. As a result, shareholders entered the Chapter 7 proceedings without access to material information concerning the debtor's investigation. Like, again, this is all company-owned property. Even more reason to just invest in companies that exist in Delaware. Because at least in Delaware, you only need one fucking sinking chair and you go fire off a books and records request saying, this is information I want to know. I plan on suing the company. Give it to me. And I have to fucking cough it up. Or, you know, you can just sue them to get the books and records. Like, just, again, if the company's incorporated in Nevada, it's not good news for shareholders. Movement also transmitted a written communication to the company concerning voting materials, leadership changes, and the status of ongoing investigations, while a shareholder raising concerns regarding the removal of the prior chief executive officer, the subsequent hiring, and near imminent resignation of the interim chiefs. And that's in the back. Again, litigation funding disclosure and current operative funding structure. Oh boy, we're just going to get worse and worse down this list, aren't we? Records reflect that litigation funding has been referenced in connection with the investigation and potential prosecution of claims. However, the nature, scope, and current operative status of any such funding arrangements remain unclear. In connection with the retention of Special Litigation Counsel, the trustee represented that the litigation funding source has been arranged to cover costs associated with the investigation and potential litigation. Subsequent filings, including applications to employ additional counsel, characterize later arrangements as materially similar to prior agreements. However, the record does not identify any funder, the terms of any funding agreement, whether such agreement remains in effect post-petition, or whether one or more funding arrangements exist concurrently or sequentially. This, I'll actually agree, is a good question. At least on the level of, is the financing to the law firms and then to be paid back by the estate, or is the financing solely, you know, is an apparatus of the bankruptcy estate? Because if it's the law firm taking out the funding, taking out these agreements for litigation funding, then it's really not the business of the bankruptcy estate. But if it's the estate itself trying to provision this funding, then yeah, it is something that the creditors and shareholders should know about. But something tells me that it's funding that is being done by the law firms themselves, knowing that how much they're going to get paid by the estate and what creditors are willing to offer them, in which case the bankruptcy court has no authority over those dealings. But I'll give her this. It's the one thing so far that's an actual legitimate question that maybe needs to be clarified. Is it the law firms that have sought out the credit funding to fund things and then will be paid back out of the money that they'll get from the estate for their services, or is this funding from the trustee and the estate itself? Would be good to know, even if it's a dumb question, in which case I'd normally say that there are no dumb questions, but that's definitely not a bad question to ask. Clarification regarding litigation funding, governance, venue, trust administration. In addition to the absence of clarity regarding the identity, scope, and operative status of any litigation funding arrangements, movement respectfully seeks clarification regarding certain governance and venue provisions reflected on the face of the litigation funding documents referenced in the record in both. Specifically, both the litigation funding agreements designate Harrison. Oh my goodness. This is really dumb. Oh, this one was really dumb. Let's go. Harrison County, Texas, as the form of the resolutions of the disputes arising under those agreements, notwithstanding that the bankruptcy case is pending before the court in the District of Nevada, which is my first hint that this is probably funding that was organized by the lawyers for themselves to fund doing the litigation that would then be paid back from the funds that they got from the bankruptcy estate. That's what this seems to make clear. Because if the funding is coming and is designated that, you know, litigation funding agreements be designated in Harrison County, Texas, Wes is from Texas, his creditors are probably from Texas. That's why they've set Harris County, Texas as the place to resolve the disputes as resulted to the credit. Like, that's just basic deduction and reading skills at that point. Like, the only reason that you would find something conspiratorial from that is if you were actually willfully trying. Like, I have a predetermined conclusion and I would like to get to that outcome. How best can I get to that outcome? How about I make something out of nothing? How about I make a mountain out of a molehill? And at that point, like, I like, at this point, like, seeing some of this stuff, I can see now why Wes Christian is suing Scott Trout for defamation. Because at this point, some of this shit is just like bordering on outright harassment. Like, if I, who has not been following this bankruptcy in the slightest, can read her own filings and do basic deduction skills and be like, oh, well, I mean, it makes sense if Wes is the one doing the financing arrangements like he's done in other cases that we've talked about on this channel. That seems to be a thing that he's kind of proficient at. And he's doing financing for the lawyers, not the estate. The estate has nothing to do with the financing. It would make sense that the financing rules are being set in Texas by Texas financiers that Wes knows in Texas because he's from Texas. Like, all this makes sense if you understand that it's Wes that's taking out the financing, not the estate. That's just basic deduction. And now you've got people like Danielle and fucking Scott looking at basic things that normal people see. Oh, well, 1 + 1 = 2. And they're like, how does 1 + 1 = 5? I don't understand how 1 + 1 = 5. There must be some crime here. There's no way 1 + 1 = 5. Well, no shit, dipshit. 1 + 1 = 2. It's like right there in your own filing if you use your brain. In addition, the basic filings relating to the second litigation funding arrangement associated with a retention, it appears that Mr. Adler is a manager of the trust administrating the funding structure. Again, more proof that it's the legal team that's in charge of the financing. It's them that's doing the financing, not the estate. Like, Further movement has been unable to obtain disclosures of the identity of any of the litigation funders because it's none of your fucking business. If it's a private entity that is not attached to the estate, there's no reason for you to. This is what happens when you get conspiracy theorists in a courtroom. It's wild. Movement raises these issues solely for the purpose of clarification. Oh, sure. Just for clarification. I am just asking questions. I'm not accusing anyone of anything. I am just asking questions. Clarifications regarding the representation of litigation funding secured and deemed contributions. Litigation funding agreement, docket 98-2 reflects state commitment of $11.8 million. However, Section 2.03 agreed further to provide that 500,000 of the commitment is allocated to the matter from the Harrington case and deemed spent as of the date hereof, and the accounts and methodologies in the Harrington case. Based on the record before the court, the Harrington Global matter remains pending. Let's see if we can go find that. I, too, would like to know what this is. Luckily, we have Pacer to the rescue. Harrington Global matter. Oh, let's log in. Case number 121 CV 00761. Harrington Global Opportunity Fund. Is that it? Dun, 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 dun. Dun, 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 dun. I hope this is the case we're talking about. Something else. So cover sheet help us. What in the world is this shenanigans? Well, that's not helpful. Oh, here's the complaint. Harrington Global Partners, Harrington Global Opportunity Fund Limited. This seems familiar. Ah. Okay. Further provides that 500,000 of the commitment is allocated to the matter from the Harrington case and deemed spent. Based on the record before the court. Yeah, I get what the implication here is they're just disclosing that they have another litigation that they probably took out some sort of financing on, and that they took the money that they got paid, gonna spend it on that. Like, are you mad that they disclosed that? And again, we get this ending thing here. Movement does not issue the challenging counsel's experience or qualifications. But funding structures may reflect actual value reported to the state. The court must be able to distinguish between present funding. I'm just asking questions. I'm not accusing anyone of anything. I'm just asking questions. Disclosure of flamethrower. Record reflects that James Christian, through one or more law firms and affiliated entities, represent or advise multiple parties connected to the issues of metamaterials, expert cards, flamethrower. Despite overlapping reputations, the representation of the bankruptcy record does not disclose the full scope of the relationships. again, you like, of course it, like, if you think that there is a representation that isn't forthright, like, Share Intel, he fucking owns Share Intel basically. I'm pretty sure he actually does, or like they're partners. Like we already know that. Like, what do you mean? Like, Flamethrower has nothing to do with the estate. Next Bridge has nothing to do with the estate. Unless, they decide to sue the estate over things, but like, you need to do more than trust me, bro, and I'm just asking questions. You need to actually point to identifiable things. In a separate litigation, Mr. Christian stated that Share Intel was unable to obtain Broadridge shareholder position data absent a subpoena. The bankruptcy record, however, does not clarify what data, if any, was obtained by Share Intel. Special counsel, what data was obtained from who and under what authority? Movement does not allege the improper. I'm just asking questions. Meet and confer efforts and inability to obtain clarification without court intervention. Consistent with court's guidance, Movement undertook a good faith effort to obtain clarification on issues. Movement participated in a meet confer conference with counsel for the trustee on 2 occasions. The first occasion was on October 16, 2025 hearing, and the second occasion was December 31st, 2025. Subsequently transmitted follow-up written communication seeking clarification regarding the investigation scope, litigation, finding access to, and shit that you don't have access to. You're not the client. Despite these efforts, Movement received no response to either follow mails. Again, attorney-client privilege. Need for court determination and supervisory clarification. Actually, there's none needed here, but hey, if we're working with conspiracy theories, why not? Issues presented in this motion reflect unresolved ambiguities concerning investigative scope, data acquisition, evidence preservation. Taken together, these ambiguities prevent the court and parties interested from determining whether MMAT and MMAT, like, again, this just feels like you're hijacking the metamaterials bankruptcy for MMTLP related nonsense. That's what paragraph 96 seems to suggest. Movement does not seek findings of fault or premature. I'm just asking questions, bro. I'm just asking questions. Clarification is required regarding Rule 2014. Clarification is required regarding shareholder data acquisition. No, not really. Contemporaneous communications with marriage support. No, not really. Determining whether supplemental disclosures are required. Determining whether supplemental disclosures are required. Determining what litigating. Like, again, if like there's no determination the bankruptcy court can do if it's funding that's being done by third parties. Like, if a lawyer hired by the estate is the one doing the funding for itself, not the estate, then irrelevant. Determining what litigation funding arrangements, if any, are currently operative. Determining what, like, again, irrelevant. Like, I can't be bothered. We got an hour left. I'm gonna have some fun. Like, I know I wanted to get to the Andrew Left stuff, and maybe I'll squeeze it in another time, but I really want to see how much of this abject stupidity I can tolerate. Because I usually set these out. I don't know if our one Twitch person is rubbing my axe, but I assume that. All right, that's right. Sal blocked me. Yeah. Oh, well, I got a way around this. Don't you worry your pretty little heads. Don't you worry your pretty little heads. We're just gonna log out. Problem solved. Amazing. we're gonna speed this up. I want to make some popcorn. Anything going on here? Am I just missing something?
And at the end of the
Oh, there we go.
치는 사람도 아니에요.
와우.
이제 자기 펀드 이제 한 1빌리언 달러를 좀 돌렸었던 상황인데 그때 이제 미국의 금융시장의 붕괴를 예측을 미리 한 2년 전부터 해서 숏을 크게 잡았습니다. 그리고 400% 수익을 냈어요. 예, 그런 주인공이죠. 그래서 그거를 이제 왜냐면 그때 당시에는 막 은행들에게 딜을 상품을 이제 만들었어요. 그럼 파생 상품을. 그래서 게임스탑에 지금 진입을 했습니다. 이 사람은 그러니까 막 사람들이 생각에는 그걸 운영한 사람이기 때문에 펀드 운영 사람인데 롱 잡고 숏 잡고 둘 다 탑에 롱을 때린 게 풀패 요거 남았습니다. 게임스탑이 이미 그때 당시에 있었어요. 이 사람이 그때 제가 저번에 마이클 버리가 했는데 그를 퀴즈가 터지기 직전에 그거는 제가 되기 시작.
copy in his native format.
Oh man, it was Duolingo.
Yeah, let's get started
All right,
because
another space.
you guys have wasted
Oh,
too much
God.
time, and yeah, I need to get this done. It's like 11 p.m. here, and I'm just playing you copy in Korean full volume in my house. So good afternoon and good evening to
Oh.
everyone. Thank you for joining today. I know many of you didn't even want to join. You didn't even want me to host the
All right, let's
space.
start some
400 people
popcorn while this
voted no,
stupidity's
but here you
going
are.
on.
You're still listening in like creeps because you have no self-control and no restraint, you big perverts. So thank you to everyone. You know, the listeners, all of the speakers up here today. This does feel like a bit of a bukkake that's about to happen because it's 5-on-1 on Atobitt. So I wanted to talk to Atobitt because of his House of Cards DD on Reddit. This was one of the first proper DD pieces I read years ago, back in the day, and I'm sure many of you also did. I know there's a lot of accusations going around plagiarism and Reddit mod psyops, but I don't really care. What we're here for today is to discuss the shell of the former Bed Bath & Beyond estate, currently known as 2023-0930 DK Butterfly. So let's do some introductions. For Atobitt, he's new to everyone here. Atobitt, do you want to introduce yourself first, and then we'll let you know kind of who's up here and why we're up here?
Yeah. I appreciate it, Sal. Thanks for the opportunity to do this. I just want to come in, have a good discussion. We'll just exchange some views. Probably should address the elephant in the room at some point. We might do it after we go around and do introductions, but a lot of questions about like where I've been and why I'm here now. So happy to get into those, but yeah, just looking forward to the conversation. Thanks.
You caught me as I was just trying to change the space title, and I couldn't put my mic back on, so I had to stop halfway. Jake, introduce yourself. Not a lot of people know who Jake is in the community. He's pretty quiet usually and unknown. Jake, who are you and why are you here?
I don't know yet. Hi, how's it going?
Hey, Jake, good to meet you, man.
Hey, man, nice. Yeah, absolutely. Likewise. Are you trying to title the space you copy? I thought we were going to do the entire thing with a translator.
No, and how dare you interrupt me while I was typing it again? I was like halfway through typing Atobitt, and that nearly came back to talk to you.
Oh, I thought that said you copy / Atobitt.
No.
That's
I was
my
typing his Reddit username handle so everyone gets where it's from. Jake, thank you very much for that introduction. Sunny D, go ahead.
I didn't even get to say
That's what
anything.
you did. I wasn't listening. I was typing.
Just kidding. Just kidding.
He's of the community. I'm like the peacekeeper, and I think.
Yo, Sal's the peacekeeper, huh?
What's up, Atobitt? We've spoken before. I'm just here. I'm really like good cop to Jake's bad cop. Jake, very aggressive, very little tact, and just like he's like our attack dog. So I got a leash on him. And other than that, I've been in this play for just like Mags, 84 years. I think when you and I spoke, you kind of left the play. I don't know exactly when. I'll let you do all that explanation. Early Bed Bath, I think, and my fascination with the Bed Bath play has only grown, and I hope we can get into the minutia of that in this conversation. But I will say that it will be impossible to condense 3 years of granular detail and various forms of low quality and high quality tinfoil into a few-hour conversation. So I think this is a good opportunity for the community to have a refresher, myself as well, and for us to bounce these concepts of someone who understands DD but wasn't in this part of the play.
Yeah, for sure, man. Yeah, it was awesome meeting you and had a great time, you guys. Just happy to be here. I don't know if I should get into like what has been going on with me and where I left off with Bed Bath and.
Yeah, go ahead.
Okay,
Give us an intro.
So basically, I think this has been like 10 days to 2 weeks of
and at the end of the day, I mean, we don't need to agree, and that's fine because it doesn't change the outcome. Only time's going to prove that correct or incorrect. And I think on a positive note, the best part of Atobitt appearing in the last few weeks in this community is that he unified a lot of people who usually attack each other, and we all got to direct it towards a Reddit mod again. So at least that's a positive.
Very fair.
I did laugh at some of the names I saw you being called this week. I saw Twatabit, Fatabit, Atobitch, Atobald, Take a Shit, Atoshill.
Shatabit,
Just
Shatabit.
yeah, just so many different names, and it's hilarious because X is so unfiltered and unmoderated compared to Reddit, and I think it's good and bad. There is bots, there's a lot of bot activity, there's a lot of people that are just talking nonsense daily on so many subjects that they don't have a clue about, whether it's politics, whether it's stocks, whether it's everything. There's just so much of it on here. There are people putting out genuinely good information, and I want to make it clear that no one is speaking in absolutes. No one is speaking in a conclusive manner that stating anything is guaranteed. What we're trying to say is something was deeply wrong with the way this company was managed. An activist investor saw this and he acted, and we believe there's a path to reissuance within the plan, despite currently there being no intentions to issue equity, which we're all very, very, very aware of. We know it's a cancelled, worthless stock with no recovery. However, that doesn't guarantee change in the future in the event of excess waterfall funds. And in my opinion, this whole venture was about accountability for reprehensible actions which were being committed in broad daylight with no one holding people accountable. And I don't want to come off offensive with this. As I said, I'm one of the most positive guys in the community. I believe that the amount of information that you need to, and I mean you personally, need to absorb about the Chapter 11 itself, the whole mechanics of bankruptcies, I think it's a lot to take in over a few weeks. I think perhaps you're not at the stage of knowing all of the dynamics at play, all of the pieces we've seen moving over the last 2 to 3 years. And personally, my opinion is that a divisive Type D reorganization happened during the Chapter 11. I feel like the plan owners right now, 6th Street, are waiting to resell the estate to a future plan sponsor. I believe we're working on a lot of circumstantial evidence which we've pieced together with what has been provided publicly. I think there's certainly a dichotomy between what's occurring behind the scenes and what's the public-facing narrative, and I believe largely that's to do with strategic withholding of information and
shares to be like renewed or revived somehow, and the conversations that happened around that were like, well, all of this depends on a successor coming in or the shell, and we can define what that shell is. I'm happy to do that because I still don't know. I don't know if like the DK Butterfly and the DK Butterfly 1 are legit things, if it's a typo, if I don't know. So those are the kind of conversations I want to have. But so is looking at what the thesis was as this movement has gone forward and come to the point where it is now, where there's still a play here, there's still a narrative here, but trying to figure out kind of how the narrative has had to shift, if you will, over the past 3 years to still
see if I can get some help from some people.
I think there are a lot of people in the community still, like I had people just telling me, maybe even this morning, that like the Bed Bath and Beyond, the YQ, like I just call it the Dead Bath and Beyond, like the YQ shares, somehow playing into like reactivation and then a like a squeeze to try and capture all these naked shorts and stuff like that, and then seeing that's kind of become an agreement that like that's not the likely play now, and it's more of this asset carve out, which I'd like to also get into more detail on to figure out what's going on there. But I'm just trying to piece together that, and from a like a current standing, I do think that this reads more like a Chapter 11 with a wind down and not a reemergence. But that's where I'm lacking like that 3-year context where you guys have put in all the information to figure out what is possible. So that's where I'm at, and I don't know where we want to start there. I know, Sal, you mentioned like we did have a conversation a few days ago with I think we were talking about the like we were about to segue into fraud, right? And then we jumped onto different threads and we had different conversations where we were talking about, I think, the bid, like the asset bid, right, for Bed Bath is going bankrupt, and they've got like these 2 offers from Dream on Me and then from Overstock, and you were making the point that Go Global also had like a $60 million bid, and I was kind of looking into that. And then I also had a conversation where I left off with Jake a couple days ago on what the play was for this reverse merger. So I think those are great points. We can pick up on either one of those, or we can also go into something that you feel is
I've noted those down, so I've been taking notes as you were talking. To start off with, before we go into more of a chronological timeline, just to lay out a story that's been going on here. When you spoke about what's there to acquire, and Jake, I know you're gonna have some thoughts on this too. Jake, do you want to go first on what's the shell and what value there is to acquire, or do you want me to go first?
You know what?
Oh
I'm
boy,
happy to jump in
Jake.
whenever. I don't really know how to try and
Mental
condense all
midget
of this
Jake. Let's go.
in a way that would be, I guess, fitting for the format we have here. I think, Atobitt, you've asked a few good questions. Sal, why don't you at least pick where
So
we would start, like you're saying, from the
I've got a
outset?
lot planned of how the best way to kind of go through just the timeline of what happened. Just to that one main question, because he did ask me the other day as well about what's left to buy and what would Ryan Cohen actually be acquiring from the estate. So there's a few entities right now which coincidentally were the same entities that had bonds held against them in 2022, October the 17th, I believe, the same day Ryan posted a photo up with Carl Icahn. And one of those entities is called BBBYTF LLC, which is a huge fulfillment center, a 14-minute drive away from GameStop's headquarters. Now, as far as I know,
Okay.
Flexport had a deal with this warehouse, and it's in Texas. And I think people have driven to the warehouse. I don't think it's in full use right now. I think that it's such a huge warehouse when we're looking at it on Google Maps and the scale of it. It's definitely a strategic acquisition tool, or something that Ryan Cohen would see value in, especially because he wants to pivot to more of a e-commerce platform, and just having something like that with the logistics of Flexport, perhaps using something like Shopify too, and using his experience with Chewy. I think that would be a very strategic acquisition, is that huge Texas facility. And GameStop obviously conduct a majority of their business in California and Texas as well.
I'm
Another thing
betting it gets
That
good
voted
right
in
about
favor of
here.
the plan, and the reason for that is because while the dip was being negotiated, or
But if the global head of M&A is worried about Ryan Cohen, one stock out of thousands of stocks on the market, JP Morgan have so much assets under management, yet they're worried about Ryan Cohen. And he was emailing the board saying we need to do something about this. Ryan used JP Morgan to sell his shares. They likely leaked the information. Discovery has been requested on those transactions, which is due anytime in the next few weeks in court. JP Morgan took too long to sell his shares. He kept emailing them, and there's proof of this as well, that he's trying to sell his shares, and he was unable to. Gustavo Arnold, the CFO of the company, was concerned as to why JP Morgan were helping Ryan Cohen sell his shares, and all of this is documented via emails. And
why would that be a good thing for you guys? I'm so confused.
if you consider his last corporate action, and it's something I really want you to understand, put yourself in the mind of a CFO. You're running a company. You've been signing off billions of dollars of accelerated share repurchases. You've been recklessly burning capital at the company's expense. You haven't stopped. Yet 2 days after he signed off the FILO to 6th Street, he committed suicide. That was his last corporate action. Why would you do that? Because he's handed
Oh my goodness. Wow. Can you just not let this guy die already?
over the keys of the castle. He's handed over the estate in the event of bankruptcy to another company, which JP Morgan did not have control over. And that's exactly where we are today.
Jake.
Thank you. If I could just, that was, sorry, Sal, I just want to go back. That was really good and really detailed. I just want to go back before I forget. The important thing to point out here is that through their liens to force decisions on the company. The 6th Street credit bid is not an isolated thing that happened. It is just 6th Street and their creditor position and how they established the super priority over the bondholders and took over the liens on the assets to, basically decide what's going to happen with them, was exactly that. It was just intended to, to cut and sever the ability of these creditors to make the decision. The real recovery and the real way that this happened was through the third-party release. Because as soon as the ownership and the result was decided, which is when the DIP was not vacated, essentially the moment that the judge ruled that the DIP would not be vacated and that it had legal standing, it was game over, right? Because the bondholders at that point could not swing their weight around to change any of the decision making that was going on. And so the moment you had 6th Street in position and had control, that's when you introduced what was called the third party release. And this is what I was talking about, that you had forced the hand of the creditors to come to the table to negotiate the third party release because they had no other choice. Up until the DIP was, while the DIP was being negotiated or in court, we were wondering whether it was going to be rolled back or not. The folks that participated in the third party release thought they had a chance, right? That they may not have to come to the table. But the plan says this, that the moment, that the third party release was presented, the third party release is actually what brought everyone to the table. But the only reason that it was our thing is because the control was taken away. And as soon as the control is taken away and the result of the company not going into Chapter 7 is taken off the table, they were exposed for whatever it was that they did that resulted in them agreeing to the release. So a third party release is again one of those things, just like a credit bid, unless you have some of the debtor, but who is that on the one of the unsecured creditor are equity. Legal standing doesn't exist. What we discovered was the plan administrator had taken over at 39 million, then on only logical explanation, he only cancels 701 million shares. 101 million shares. Right? So the third party release has to involve someone that's not the company. And the plan, so if the holder of interest had a right to effectuate the third party release and he's a shareholder or she's removing information from the your question, how does that resolve in recovery to shareholders? Well, it has to, because you can't discriminate within a class. And if the holder of interest has to be a shareholder, because that's how they are defined and identified in the plan, well, then all shareholders have to benefit from the benefits that the holder of interest will. The third party release, again, if it involved a third party release, little or nothing, to shareholders, if you are the bondholder, their recovery entity, which are going to offer the rights offering, the plan
Does he ever stop fucking
release.
talking?
In fact, as the player, but the other
Does Jake
can't vote
just like
against
the
your
sound of his
as
own
the
fucking
make the claim
voice? Is that
to not
the problem we're having
acquire
right now?
super more money. This benefit is going to get their are getting, and the nefarious actors.
And I don't think you'll get there tonight.
Appreciate how much information. I know there's so
someone is the holder of interest. I believe it to be Ryan Cohen. Doesn't matter who it is. Someone who is the holder of interest held the company and the nefarious actors to account, forced them into a settlement, and they themselves are a shareholder, which means that you have to award shareholders because you are not allowed to discriminate within a class.
I really, really appreciate how much information. I know there's so much in your brain. You're trying to get like a lot of stuff out, but I'm trying to follow like one thought at a time so that I can string this along and follow, and we can have a discussion on each point. Because you're making so many points here, and it's not a bad thing, but you're making so many points that.
Thank you. I like that's Jake's whole thing. Jake's whole thing is to just gish gallop. He doesn't have a point. His point is to just keep shotgunning bullshit and hope you can't keep up. That has always been Jake's thing. All he does is gish gallop.
I don't have the opportunity to ask a question about how you're getting there.
And I don't think you'll get there.
Thank you. Holy shit. Man, he just basically calls out Jake for his bullshit. Amazing. Thank you very much.
I think the great takeaway is, and thanks for all these great speakers up here today, is you need to take the time. It's probably going to take you a couple months.
Yeah, and I
So-
understand that, but they're very like building block foundational things. Like the question around like what is the holder of claim or holder of interest and how they pertain to the plan, and you're talking about whether there are certain impairments that happen under the plan and whether people were voting to accept the plan or not accept the plan, and the language in the bankruptcy statement or the bankruptcy plan itself, which to my understanding has not been altered, that did cancel shares, is very clear on what that definition is, where it's binding to the debtors and all of the the wind down debtors and everybody involved. And then
Sorry, can I just cut in there? I just want to disagree. And I put up a post about this the other day, and I'll send you the link to it. Essentially, anything that's in the benefit of the creditors or the stakeholders of the estate, if any new emerging money comes in, whatever, it can be adjusted. And yes, the plan is binding. However, Article XIII of the plan says retention of jurisdiction, and Section 7 of that says that they can enter and enforce any order for the sale of property pursuant to Sections 363, 1123, or 1146A of the.
I was just saying that the bankruptcy estate has jurisdiction over it, and that all orders have to be approved by that doesn't. Sal, shut the fuck up. Like, you don't know shit.
Bankruptcy code, and this can be done at any point before the final decree. So as long as the estate is still in Chapter 11, the final decree hasn't been issued, it can be changed as long as it's for the benefit of the estate. It can't be changed for more adversity towards creditors. And they have no legal right to reject anything in the future, because why would you reject free money? And this is why we say the structure and the framework for reissuance is in the plan. Nothing prohibits the resale of the estate, which is why there's many terms within the plan that explicitly
Right.
refer to a successor.
The plan allows
Sure,
for it.
The successor or the assignee.
Yeah, and I'm not disagreeing that the language is there for. I mean, you never know, right? When you're creating the bankruptcy plan, things can totally change, and you can receive bids from third parties that totally change the way that the liquidation process is going to go. What I'm trying to do right now is get an understanding of the plan as it states, the language in the plan, who's bound to the plan, and the very explicit language after that cancels shares. And up to this point, like I know you were talking about, the different numbers that are referred to in the documents, like it to me, I don't understand how that point or that argument is relevant, because, and I don't mean, again, I'm not meaning this in a mean way. I'm trying to understand this. When they say all issuances, like all equity issuances as of right now are canceled, I don't know how
Except
that's.
for what?
Of course,
Sure. So
there's
there's
not any illusion around that.
there's a
actually
very
like
easy
that.
way to explain that. And so there are two things. The language that you see is up until September 14th, and it exists that way because it has to, right? Because they wouldn't, you can't get confirmation otherwise without a cram down. The plan also has, and again, this is recorded, and I'm using the specific words that are in the plan so that you can, hotkey search them or word search them to find where they're found that will explain what I'm talking about. The plan does reserve the right to modify anyone's recovery. That's not made up. That's from the document. It allows shares to come back. It's called an allowed interest. It says any claim or any interest can become an allowed interest at any time. Here's the thing is, because you make this is a good counterpoint where you say, they may have had the best intentions, but then maybe something fell apart and they couldn't do it, and wah. We know that can't be the case. And again, this comes down to again,
that can be the case, but you act like it isn't. And it's not like like that is the default case. That is the most likely 99.99% case. Like, you all are basically hoping and wishing some angel investor comes in and bails out your bags, which is not fucking happening.
we are having this discussion as a summary of like 3 years of work, right? So this wasn't all known at the beginning, and this has all been found in pieces over time. But one thing that is undeniable is that, and this is from the United States of America uscourts.gov website, they say that you are not allowed to confirm a plan without repaying your tax entities, because you have to allow taxing authorities the most senior priority lien status on assets.
Right. They get the tax man gets paid before the government gets paid before everyone else. That's why the plan administrator has said that the estate is insolvent. It's likely it won't even pay back its first lien debt holders, let alone fucking anyone else below that priority.
So that if there's ever any level of recovery, that they have the first dibs, right? However, what happened was, in this case, the plan was confirmed, and the tax authorities have still to this day not fully been paid. That is not allowed.
Exactly, which is just more proof that you shitbags ain't getting fucking shit. Like, how can you not have those words, Jake, come out of your fucking mouth and not realize how fucked you are? Like,
So the only explanation for how you can have a confirmation and have the taxes outstanding and unpaid is because
it's because you ain't getting fucking paid. There's no money to even pay the tax burdens. There's nothing. There's nothing there. Taxes take top priority. That doesn't necessarily mean that there's enough to pay there. Like the tax man will get what the tax man gets, whatever money's left in the estate, and they'll get the first dibs and they'll take fucking everything. Like, how can you say that and not understand how fucked you are? Like, it baffles me.
Because there was more money coming. And it doesn't matter if we don't know how, and it doesn't matter if we don't have all.
Let me get this straight. Instead of understanding the basic concept that if the tax man ain't getting paid, I ain't getting paid because there's not enough money in the estate, Jake makes the retarded reduction that if the tax man isn't getting paid, that means there's more money coming, therefore I'm getting paid. That has to be the most retarded thing I have ever fucking heard. And that list used to be pretty short, and then I started following meme stock. So A+ on your participation ribbon there, Jake. Wow, that was fucking dumb.
All the information, or if we don't know if the plan was modified or how it was modified. There are undeniable elements in the law, like how the NOL has to be preserved, how in this kind of a reorganization you have to.
It's only preserved if there's a going concern. There is no going concern, eat a bag of dicks.
Issue shares. Similarly, you cannot confirm a plan, whether it's a Chapter 7, Chapter 11, plan of liquidation, plan of reorganization, unless the taxing entities are paid. And so the only way you
There was a plan, and there's just nothing in the state. They don't get paid near as much in whole. Like this is just proof that you ain't getting paid shit.
you can get around that is if you agree to an alternative treatment for them, right? So again, they have to agree, because otherwise they can just say no, and they can just sit on all the assets and say, well, if somebody comes around and even wants to give 1 cent on the dollar, at least we'll get some recovery, and we'll sit on this for 100 years if we have to.
That's what they did. We'll take whatever recovery, and the rest of the people, the bondholders, not even the equity holders, the bondholders, get fucked.
But there was a consensual agreement that allowed confirmation, which is that you will be paid later on. The only way that that happens is if all of these other things that we're talking about is true, because again, 6th Street is in the first position. They can't take the asset, and yet they did. And the taxing authorities are paid. So at the very least,
I swear to God, the only way you could come to that conclusion is if, like, you're in Bizarro World. Jake over here trying to bend himself into fucking pretzels and just exposing himself for what a numpty fucking idiot he is.
you know that all of the tax bills have to be paid, which is already millions of dollars. So who's doing that, right? Well, you may say that 6th Street did that because they, they see the value in paying $10 million worth of tax, because maybe they have an asset worth $500 million that they can sell for 10 cents on the dollar. They can still make money.
Yeah, Jake,
Well, we have. Sorry.
I'm so sorry,
Yeah.
man, but I'm like I don't know where you're referring to in the bankruptcy plan that allows for reactivation of shares. So that's kind of what I'm saying. I'm trying to ask like that question.
Thank you! Thank you for stopping his stupid fucking gish gallop and getting him back on the point.
And then
It's called allowed interest.
what
It's called
And
allowed
interests
interest.
are?
right
It's in the definition
Yeah,
section of the plan.
the definition
Just to bring you up to speed, Whisperbit, is anytime he refers to interests, the capital I within the exact definition of the plan refers only to securities. So whenever Jake says interest, he's referring to securities.
Yeah. So if you search allowed interest in the plan, one of the definitions says that any interest can become allowed at any time. And one of the references is actually in the liquidating trust, because that's the mechanism through which it will all happen.
And I'm tracking with you there. I'm understanding that.
I think the sentence is up in the nest. You can just read right from that doc. It's like one sentence.
I know where the allowed interest section is. I get what you're saying, but once the shares are canceled,
Did you read
How-
the
They
sentence?
cannot be
Did you read here?
uncanceled. Like, if the plan, like what Atobitt is getting at is, if the plan had, like if they had contemplated the idea that shareholders would ever be an allowed interest, they wouldn't have canceled the shares. But you know what they did, dipshit? They canceled the shares. And there's no uncanceling the shares. So guess who's fucked? All of ya.
no, I know.
Shall I read it out for you?
Like, there's
Something
no
else.
No,
way
hold on.
you
I
can get
just
around
like to
that.
hear the question. Hold on.
The definition of the allowed interest allows for things to be added to the the list of interests, or we can define it as just equities here. That's fine. It allows for things to be added to the list. I'm not getting the connection between canceling the shares from this point forward and reactivating those to put them back into the list for allowed interest. Does that make sense?
Yes. So the answer to that is they are defined in the plan before confirmation as being common stock. So anytime you have interest with a capital I, it refers to common stock. So having an interest becomes
You broke the Jake bot. The Jake bot is broken. All it can do is just circle around like a broken record on the stuff that he's pre-programmed to do. Atobitt has fucking have busted his ass so hard with a question that he just cannot compute. Like, who cares what the fucking bankruptcy plan says about added interest? Like, you can't undelete the fucking shares. They have been canceled, deleted, liquidated. They don't fucking exist anymore. Who cares what, like, if the bankruptcy plan says that you can add in whatever interest if you get the money? The fact is that the shares were canceled. There's no uncanceling the shares. So there's no way for you all to have a recovery. Like, the bankruptcy plan didn't even contemplate that, because they didn't even contemplate back, getting money for unsecured creditors, barely, like 2 cents on the dollar. So, like, they canceled the shares, and there's no way, even with, Jake's hoopty allowed interest, bull crap, that they could ever get fucking paid. And Atobitt keeps pointing that out, and Jake keeps trying to run the fucking rinse cycle, and I have a feeling this is going to it's just going to end in bad places.
an allowed interest is making recovery for shareholders. Because interest with a capital I exists before the confirmation and identifies interest as shares. So anytime the capital letter is used, it can only refer to that specific thing. And so in the context of the plan, that is the common stock of Class 9 shareholders. So that's why when you see holder of interest, third-party release, allowed interest, that can only refer to the common shares.
I'm not sure.
No, it cannot. No. Interest is any interest in the debtor. Any, like, chance of recovery. Oh my fucking God. How can you be this fucking stupid?
It's in the plan.
It's a limitation of just common shares.
Docket 21.
Yeah, it is. It is. If you look up interest as the, in the definition section of the plan, it tells you that interest is any equity security. But the only equity security that existed was common stock. So there is no other interpretation.
And you're saying
you can't later change the definition of what it is. You know what I mean? Like, if you go into confirmation with it identifying as a specific thing, you can't then change what it is after. And since it existed as identifying, again, this is just interest. If you Google, or not Google, if you search the plan in the definition section for interest, it specifies that it is any equity security conforming with 101.15 of whatever law it is, I can't remember. And then it tells you that it's either common stock or it's a derivative of common stock. But the only thing that exists at the time of writing of the plan is common stock. So it can only refer to that. Otherwise, it would be defined differently, because you would not have, either you would be legally liable or you would not have legal protection. So, attorneys billing $1,500 an hour are not going to make that kind of a mistake in the document, right?
Okay. Actually, I got the plan pulled up, and where did you say the interest section, the definition for interest, is it under the capitalized
the definitions? It says interest.
I think definitions are like in the first 15 pages. I don't know. It's like you see the individual words in quotations and then
the capitalized
a summary
terms
of them.
we're talking about. Okay. So your statement here is because they have this term. Am I like whispering or something? Can you guys hear?
I don't think it's you whispering.
Oh, is this the
I can
whisper
hear you.
part that I heard about? Okay.
You're saying because they are defining interests as equity, that the shares after being canceled cannot or are available to become or allowed to become reactivated, because the definition of the allowed interests incorporates that.
I don't understand what you're saying.
Yeah, you had a lot of gaps between those words.
Yeah, I'm trying to wrap my brain around.
He's trying to wrap his brain around how retarded you all are.
Participating in the third-party release. What else could the holder of interests hold other than equity securities?
Right, and that's what I'm saying. I think that's a generalized term. That interest.
Thank you. Oh my God. Thank you. Interest is a general term for anyone who holds interest in the debtor, who is a creditor, who is owed stuff, who is, a security holder. That's an interest. Anyone who has an interest in the debtor estate. Oh my God, he's cracked the fucking code that Jake has carefully tried to hide. Holy fuck.
to be just common, but it just happens to be that they only have common stock.
No. So it does say that the plan does say that capitalized terms, and this is for any legal document or contract, that capitalized terms only mean what they are defined to mean in the plan. That's why you have the definition section, and that's why there's times where they use interest with a small lowercase I, and there are some times where they use an uppercase I, because when you're identifying or when you're using a word with the uppercase, you are identifying a concrete meaning of that word. And the plan does say that capitalized terms mean only what they are. I think that's actually the first sentence of the definition section before it.
And you
gets
can
into
understand why
definitions.
there has to be no room for ambiguity in a plan of such, important documents.
And the other thing is, like, with what you're saying. So what if it's
Sure.
just like, yeah, they are identifying that there's something might be somewhere in the future that might be a share. You can't have that in a legal document, because the holder of interest participating in the third party release would not have protections. You're basically saying that, you own these shares, but maybe that's what we're going to refer to in the future, and that will be, protecting your kind of level of involvement here. But like, maybe it'll be something else that wouldn't jive. You, as the participant in the third party release, would not accept that, because you have to have your thing defined, right? And when it uses the capital letter, it can only mean what it says. That's why I said, when it says holders of interest deemed to reject the plan and holders of interest deemed to accept the plan, we know that those are the same class, because they're both used with a capital I, right? And that's why it's still.
No. Okay. Jake obviously does not get that supports Atobitt's definition that interest is a general term, because deemed to reject would be the shareholders, because they have no go forward claims on the estate, and deemed to accept, and those that are voting are the ones that have actual claims on the estate. So that pretty much substantiates what Atobitt was saying, that interest is a general term. Again, I'm sorry, I'm doing basic legal deduction here based on things that idiot willfully said on the space, but whatever.
Stood out and immediately made sense. Well, not immediately, it took a while, but that's why it made sense when we saw that the plan administrator didn't cancel all of the shares, is because then the holder of interest would lose their standing, because it is a very specific term. And there's no explanation for that. There's no alternative
All
explanation for
shares
why
were canceled.
not all
What's
of
your
the shares were
evidence that
canceled.
they
I mean, unless you
weren't?
have one, I'd love to hear it. But when the plan administrator goes to the DTC and says, get rid of these shares, he doesn't do it for all of them.
He
Yeah,
did
so
though.
I've got. Can we like do another space?
I think you've got a lot of research to do. I
Yeah.
would recommend listening
Yeah.
back to this space at
So
least
Jake,
5 or 6 times.
real quick. So what you're saying is interest could be canceled, but also allowed.
Yeah. I mean, it's written in the plan.
I just don't know
They
how.
literally have to.
Yeah.
No,
Here-
they don't.
You should have
Bo.
done, bro.
So here's the thing. So if you can look at here's the thing, because let me I can even distill it down even further.
Yeah, it's no problem. I just have like my family's banging on the door. They're trying to get dinner and everything going, and I've
No
got
problem.
Yeah.
Even if everything I said in the last 30 minutes was wrong, what is in the nest right now, highlighted in the document, still allows for the recovery that I'm talking about.
Shares are canceled, bro. Right. Well, that seems like a good place as any to end it. I'm sorry I saw some people trickle in from Rumble. I suppose you can catch back up on some of this stuff, but man, that space, I'm sure, would drive me to alcohol, like more than I have consumed tonight. But I hope you guys tune in Saturday evening, tomorrow evening. We have our regular Truth Be Told episode, and I'm sure it'll be fun. We have a lot of stuff to get to. We'll be covering this in sort of skimmy details. We've got new stuff from AZRH and that clusterfuck, and a whole bunch of other fun stuff. We even got James Fishback stuff to talk about. Apparently, social media accounts don't like when you brandish a gun and threaten people. Imagine that. A bunch of other new stuff to go over, so you won't want to miss a Saturday as I'm munching on popcorn here. I didn't mean for us to do that. Stop that nonsense right now. Stop it. Stop that nonsense right now. Anyway, so hopefully we'll see you Saturday, tomorrow evening, for more fun shenanigans. I'm sure if things keep the way they go, I hope to have an extra after watching the hearing in the metamaterials bankruptcy, and we'll get back to you on that. That'll be next Friday. And until next time, I'll catch you folks later.